Okay, with it being after 7 o'clock, we'll call the October 27th meeting to order, and we'll start off with the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Oh, bitch. I couldn't have done that if I tried. No, I can't see, I can't even see the crowd, let alone the paperwork. Okay, we'll start off with the approval of the minutes. Did anybody, I didn't. Motion?
There appears to be.
September 29th minutes.
I haven't had a chance to review it.
We didn't get to read.
Not reviewed at this time.
Not
Not
reviewed.
reviewed? Okay.
Not reviewed.
We'll move them.
Okay. I'll get rid of the continuances. Dana Wise, 242-1787, 135 North Ramp Road, continued till December 8th.
So moved.
Second.
All those in favor say aye.
Aye.
Opposed? And that's unanimous. Next one's 242-1816, 325 Johnson Street, request to continue to November 17th.
So moved.
Second.
All those in favor say aye.
Aye.
Opposed? And that's unanimous. And 242-1831, 104 Milk Street, request to continue till November 17th.
So moved.
Second.
All those in favor say aye.
Aye.
Opposed? And that's unanimous. First on the agenda is 242-1822, 45 Katuitt Street.
Commission received a revised set of plans with supplemental information based on my review comments, the commission's comments at the last public hearing, DEP's comments. I did generate another round of comments based on these revised plans. So I'm going to let Ben just give a quick rundown, and then I'm going to let you know kind of how I've responded to some of those. And I know you guys have questions too.
Evening, Ben Osgood, Ranger Engineering Group. Here representing Seaport Homes, the applicant for this property, 45 Katuitt Street. It's an existing lot. It's about 18,000 square feet. This is a 12,000 square foot zone. It has it's on the north side of Katuitt Street at the intersection of Lyden Street. The wetland flows off of the development here, comes off of 125, to a small intermittent stream, runs down through the front of the property. So we have a 25-foot, 50-foot buffer zone in yellow and purple. Green is the 100-foot buffer zone on the upper portion of the site. So we're proposing to cross the wetlands to get to the upper portion. So essentially, we're constructing a driveway coming off of Katuitt Street. It kind of wraps around and crosses the wetland. We're using an arch culvert across the wetland. With 2 footings installed on each side of the brook, and an aluminum block arch culvert installed over the brook. We do have utilities, so we are going to temporarily disturb the area under the box culvert for the installation of the utilities. I believe we have a total of about 450 feet of alteration, 36 feet of bank alteration that we need to compensate for. We're going to, the project has sewer, water, gas, all running out the driveway. The house is up in the back northeast corner. It's beyond the 50-foot no build. We're, other than the crossing, we're not disturbing anything in the 25. We're installing a wall along the edge of the 25-foot no disturb zone. We are doing a wetland replication adjacent to the wetlands in the southeast corner of the lot. So let's see here. I'll go to just to show you the wetland replication area, a little more detail. What I've highlighted in pink here is the erosion control, and we have a construction sequence as to how the crossing will be constructed. So this is step one, we'll put the erosion control in. The erosion control will go across the brook itself. We'll put in a pipe under the brook so we can get the equipment over into the lot to install our sleeves under the brook. So there'll be an electric/communication trench. It'll have a couple of sleeves in it, the water trench, the gas trench, and the sewer trench. They'll all be sleeved under the wetlands, 20 feet out each side, 4 feet under the wetlands. So we'll have to excavate to do that, and that'll be the first step, is to get that done. The erosion control will go in and isolate that area of work. Step two, the utilities are all in. We restore this area here, and then put the erosion control kind of a parallel with the brook, so that it leaves the brook area restored, stabilized with erosion control matting. The brook bed will be stabilized with stones and rebuilt. And then we install the strip footings for the culverts, so they're on each side of the culvert. They're just a concrete 2x2 footing. They can either be poured in place, or they do make precast footings for that. So those will be installed. Then the culvert gets built above it. So it's an aluminum box culvert. It's all assembled on site, and it gets lowered in with a backhoe onto the footings, and then the site can be backfilled. So that's step two, is installing the culvert. And then step three would be installing the head walls and filling over the culvert. You build up on each side, installing over the culvert to provide access to the property, and then you construct the property. Wetland replication area obviously would be one of the first things that we would construct. It's not shown on this sheet, but this area here, before we actually make all the disturbance to facilitate the crossing, excavate out this area, and this will be done in conjunction with putting the utility sleeves in through the wetland replication area. I know that was one of the comments Amy had, was when will the wetland replication area be done? That would be one of the first items to be done, that first crossing over the wetlands, the temporary crossing. And that, I know we've talked about this project quite a bit. There's been a site walk, so I know I was brief. I think everybody understands the project, and I'd be happy, I think it's easier just to go to the commission with questions rather than have me ramble on.
Okay, thank you, Ben. Joe?
So with regard to what Ben just pointed out as a sequence from replication or restoration to the culvert crossing and utility crossings, all that's going to be driven principally by the ability of the soils to accept those types of procedures that you just outlined. But you haven't been able to get the test pits done yet, correct?
We have not. It's really tough to get a mini backhoe for 4 hours to do a test pit. I mean, everybody's just so busy, and I'm working on it. I have one person that said he would get it done for me. It's going to be another week or so.
So we've, again, I haven't seen anything happen right down in that corner of this neighborhood. And I live in the neighborhood. I'm not in the butter by a long shot, but I do live in the neighborhood, and I watched the houses across the street all be built. I watched my additions, 2 additions, be built over the years. And I know that the overburden is very shallow to bedrock. Like I said, I don't know about that far corner. It's far enough from my house where I wouldn't extrapolate, but I do know that, everybody who's dug a hole in that neighborhood has found nothing but solid ledge that they have to rip out, and it becomes a nuisance. So the question is, until we get test pits, this is a great plan, but we really don't know the feasibility of this. So I mean, this is for information until we get that information. Otherwise, that says it either works or doesn't.
I'm pretty confident there's going to be enough soil, just in digging the wetland. If you dig down with an auger, you get down 3 feet, you're still in fill. I think this area has a lot of fill in there.
And again, getting the feel walking down in to
Right.
the brook, and then walking back up that bank on the far side was
was high.
That's probably natural.
But you're filling in
Right.
that area as well.
Right. Yep.
So, but, getting that restoration area at the right grade with the right soils to function as a restoration area and perform the functions it should.
Right.
Is really gonna be driven by that soil. I had raised a question with regards to the legal status of the road, was we have clarified that the roads are not accepted in this area. But we got a letter from Public Works Director Stanford and Engineer Borghese, and they both say that they don't have any jurisdiction with regards to the roadway standards themselves, that that's a question of the planning board and the zoning board. So I guess the question still exists, it's just we need to know to what standard is improvement to those roadways going to be done. And we did, and I asked that we get a letter from DPW, because my heart's with DPW, and I think we rule the world. But apparently they, not in this sense, we're gonna need something from somebody in the planning office that either says there is no jurisdiction, or if there is, what level of construction is required on that approach. You're confident this is what you're putting in, and, for now, that is good. I don't think we're gonna close tonight, so I think getting that input from planning and zoning before the next meeting is
No, we
important.
can't close, we don't have the information from the test pits.
Right.
We
Like
can't
I
close,
said,
we don't have the
right.
information from the
So,
test pits.
meaning we have ample time to get that input
Yeah.
from the others. I know that the abutters, many of them were gathered, not as much participated in the sidewalk, but were gathered in the vicinity during the sidewalk. And, they were a little surprised about the location of the house, but we found monumentation. I mean, the boundaries of the property lines are where they are. Whether that's a surprise to the neighbors or not is sort of immaterial to this commission. Based on where we saw those boundaries, we were able to visually interpret where the building was gonna go and where the driveway was gonna go. We saw it would affect some trees. Those trees are not out, not within the no disturb zone. In fact, they're outside the no build zone. So they're not jurisdictional to us. So really, we're looking at the wet meadow and the crossing itself and those buffer zones to them.
Right.
So until we clear up those other questions, I'm all set. Thanks.
Thanks, Joe. Jack?
Yeah, again, just to reiterate Joe's points, we've got a lot of questions yet to answer on this project, technical questions, and I get it that we really won't have any solid details until those questions are answered and further design is done. I just have one question about the intent of the project. I see you've got the boundary lines marked in black around the around the lot. How much of that is going to be the vegetation is going to be removed? How much of the vegetation is going to be removed? Is it going to be completely removed within that within the boundary lines, with the exception of obviously the replication area?
Well, there's not a lot of vegetation other than grass, except in the crossing area. If you look, here's the tree line, and it goes right along inside that 25 no disturb zone. It pops out a little bit here, and then wraps around. So this is all just grass. So it's really not a lot of, vegetation, meaning woodland and shrubs and that sort of thing. It's the adjacent apartment complexes mowed it and cared for it. So it's
Okay.
just grass. So this area, obviously, there's vegetation in here. It's a lot of shrubs and
Yeah.
small
We
trees.
walked it, but in regards to that tree line, are you planning to leave that tree line intact other than for the access way into the
Yes.
lot? Yes.
Yes.
Okay.
Yep.
That's all I had. Thank you.
As a follow-up to that, Jeff? So you're showing the erosion controls, and typically that's the limited disturbance.
Right.
But
It's right along the edge
in
of the
that
tree
northwest
line.
corner, it's looking like there is some of that tree line that's gonna be disturbed. Or is that just canopy projection? I know that tree lines are very arbitrary.
Right, there's canopy and, maybe there's some shrubs there, but the intent is to go right along the edge of that existing tree line there.
And all of that's outside the 25 no disturb anyway.
Right.
Yeah?
So I have to ask Amy a couple questions.
Okay.
So, I want to talk about the wetland crossing stream standards first. On page 1 of the document, it appears to be a back and forth between you and Ben, dated October 26th. It appears that you agree with the measurement for the span to width ratio of 1.5.
Well, I think the openness ratio is met, but I think I'm coming up with just different numbers on how I measure on his plan in terms of what he has had in his narrative.
Okay.
So I wanted to make sure our numbers match. I do think the openness is met, but I want accurate numbers to say that.
If I, actually, on that question, before we get into the details on the crossing, and I meant to, I read the stuff that we got, but for the sake of the folks here and people at home, we asked that stream crossing standards, the stream stats be calculated, because it was a question whether it was intermittent or perennial.
Right.
And at this point, we know that's been put to bed, but we should announce what that outcome is.
Yes.
Yeah, because I think folks.
No, you're correct.
Yeah. So we
That's
should-
right.
Right, so it is not a perennial stream.
Not a perennial
It's an
stream.
intermittent stream.
Right.
Which means the stream costing standards are far less stringent than if it were a perennial stream.
So the data that goes along with what I'm asking, so the data that's been compiled, there is a consensus that it's an intermittent stream?
Yes.
There's evidence that it's an intermittent stream?
Yes. Yep.
If I could just, I figured out what the difference is, Amy.
Okay.
I measured the width of the stream bed. That's how I calculated my ratio, my span ratio.
Yeah.
I think you measured at the top of the bank.
Yeah, it's
Bank to
full
bank.
width is the-
Yeah, so
But
it still meets it with bank full width, but
Yeah,
that was
that's-
that was the reason. I just did the stream itself.
yeah, so I checked that too, Al.
Okay, that's what I'm looking for. I'm trying to,
Yeah, so he's still over the 1.2
he exceeds the 1.2?
requirement, and he also exceeds the openness
Right.
area. There's a little difference in how everyone measured, but, you know.
Then we have agreement on that? Okay. All right. That was my question. That was what I had. Thank you.
Okay.
The only question I have, Ben, is the main thing to me, is the road crossings on the paper streets. Now, I know they're not a public way, because they're a paper street, they're not accepted by the town. So they're allowing you to cut across, to put utilities and do your road work. However, there's two sides of the street. Who owns the opposite side of the street? What's it, Layton Street?
Lyden Street.
Who owns the other side?
Well, if it's a private way, after 20 years, the ownership goes to the middle. But
Goes to
every-
where?
Goes to the middle of the private way.
Right.
So technically, I think.
Well, it hasn't, that may not be true. Has it been abandoned by an act of town meeting? If it has not been abandoned, then the ownership to the middle does not apply. It has to be abandoned by an act of town meeting.
I don't know. I don't know.
That's a
So-
pretty
but that's-
important thing to know.
Right, but that's potentially, but regardless of ownership, it was a right-of-way, and everybody along that has the right to access their property, utilities, driveways, et cetera. So anything that's unaccepted, if you own, land along it, and it was,
If it's privately owned, and people have been using it for more than 20 years, then they adversely have possessed it. However, if it's town-owned and it's not been abandoned, it remains a town paper way. No question.
right, it remains a paper
That's
way.
well-decided law.
Right, it remains a paper way, and the people along that way have the right to
They have the-
improve it,
They have the right to pass and repass.
right.
And
with-
improve it.
And improve it,
And improve
utilities.
it. I agree with that, and improve it.
Right,
However, then, I go back to the letter from Mr. Borghese in paragraph 3, where he calls it a 12-foot wide driveway. And he doesn't call it a way. He said there will be no requirement to upgrade the existing roadways, Katuitt or Lyden, and the access to the existing 45 Katuitt lot would be considered a driveway access only.
right, that's what it is.
And again, the same question I keep asking, we agree that that's accurate?
I think the letter goes on to say deflecting it to the planning board
Yeah.
and zoning board.
Well,
I mean, the reality
no,
is.
that was in paragraph 2, but in paragraph 3, where he says 12-foot driveway as identified is all that the DPW will require for access to the lot, and all maintenance to this access way, including but not limited to the pavement, box culvert, wing walls, will be the responsibility of the homeowner. So it appears that even though I would agree that it is a town-owned paper way, or ancient way, or whatever the term you want to use to call it, at the
It's not
same.
that old. The layout's early
No.
50s, yeah.
Right, it's not too.
It's not that old.
It's still a way that the public has had a right of access without restriction. And it was a way that was laid out by the town somewhere. And it's not been abandoned by an act of town meeting.
So it wasn't laid out by the town.
Who laid it out?
It was laid out by
Private
the
developer.
developer back in the day. I had all those records,
Yeah.
but I don't have them with me now. But it was, I want to say it was 51. It was laid out, and then portions came online to be built back then when, prior to the planning board, you could build roadways within a layout with the hope they get accepted, or with the hope that at least you could build it and sell lots.
Yeah. All right.
And I'm sure I know I copied Amy, and I don't believe I copied any of the members, I didn't want to deliberate via email.
Right.
So Amy knew it and passed information on to Ben. So based on my research, Ben got information that they were accepted public ways.
Okay.
But I knew for a fact that that wasn't the case. I mean, I live on a private way, I know that.
So,
So Katuitt got accepted
Yeah.
back in the 60s, 160 feet down from
Wait,
end of a street in Chickering Road. And that's it, nothing else. Lyden came in 1967, I believe, for acceptance at town meeting. It was rejected. They came back, the condos, the apartments at the time, came in and wanted to get the roadways accepted, and including Kingston Street. They accepted Lyden only up to the curve turn at Kingston and nothing else. So that section here is laid out prior to planning board existence, exists, it's privately owned, and never been accepted. So the question is a legitimate one, and I think I raise it from two perspectives. One is, what standard is required because it affects the driveway and
Yeah.
what projects before us?
Okay.
And two is, one of practicality is, we know that Katuitt Street's not in the middle of the layout, it's random, it meanders all over the place. And that corner is damn near unmaneuverable as it is. And this is gonna make it worse forevermore. The time to address this and put it to bed is now. If the town ever has a concern with the safety maneuvering around this corner, they better say it now, because they're not gonna get an opportunity in the future.
but it's not within our jurisdiction.
Only to the extent that if they require something in that curve, it may change, it's likely to change the way the driveway comes in, that is in our jurisdiction.
Okay. So
And-
unless and until that happens,
And that area of roadway improvement is all also within the buffer zone, all buffer zone.
so unless that happens and until that happens, we're just
We're
considering.
close, I mean, we got a letter from
Yeah.
Public Works
Yeah.
and Engineering, and they suggest that we also get something from Planning and Zoning. And I think at that point, we've exhausted the remedy, and the answer is going to be out of those two pieces of paper we get.
Okay.
I think it's ultimately building inspector's call as to the adequacy of the frontage and if it constitutes a building lot, so. I mean, and then it's the applicant's risk that if the frontage needs to be improved, he or she would have to come back for a modification to anything that was issued. But as far as, what we have in front of us, I mean, it's access off of,
And I think you're right, because it would never go to zoning board of appeals,
no,
only
unless,
by way of denying
by the.
by the building inspector,
Yeah,
they
so-
they seek relief.
Yeah, okay.
okay,
I'm good, Mr. Chairman.
Tony, more?
So, I do have a couple of questions. The length of the driveway from edge of pavement to the house, it scales over 150 feet, and my recollection of the fire code's a little shaky, but I thought it was 200 feet or more. You needed to have 20 feet of clear space. Have you talked to the fire department, just to make sure?
I'm not.
Make sure you don't have, and I'm pretty sure that applies to residential, just so you don't have to come back for
Right.
an increased crossing width.
Yep.
Because that would affect the total calculations. The So I also scaled total length of bank, and I get between 200, 205 feet for top of bank distance across the property, both sides. I'm still reading 310 CMR 1054 4A5 as you get, the performance standard is 10% of the total length of bank or 50 feet, whichever is lesser, without a wildlife study to meet that performance standard. And you're saying we have 36 feet of bank disturbance, so
Okay.
you'd be over that 10%, so you'd need a wildlife habitat study. And then, based off of that wildlife habitat study, I think the performance standard, or the stream crossing standard would then come into play. It looks like you used the general standard, which I think, based off of the way the site looks, I think is the right standard, but with the wildlife habitat evaluation, if they said that there were larger animals, you might get pushed into the optimum standard, which has a higher openness ratio. But given the information we have, I think you're headed on the right track, but I think you still have some
Okay.
things to check out.
I thought it was 50 feet or 10%.
It's whichever is lesser if you read it. It's in parentheses afterwards.
Okay.
It's, and I only know because I've gotten burned on it before, so. it's,
All right.
Okay,
And,
I'll check that out.
and I'm not trying to be
I
tough, but
No.
we have to get it right too, because,
Right.
I mean, I would think,
Yeah.
you know,
So that's, DEP mentioned the 50-foot in their letter.
all
Are
right,
we-
but.
are we
But
50
if you
or-
read it, if you read the standard,
Yeah.
it says,
I'll double, yeah.
10% of the
Mhm.
total bank length,
I-
or 50 feet for applications after November 1987. So it's 310 CMR 1054 4A5. And be careful, because the top of the page says 1054, but it's really 1053, and then the next page goes into 1054.
Homework. It's the guy that reads and see about it.
I deal with them every day,
Yeah.
unfortunately.
When you're thumbing through and you just do
Yeah.
page clicks,
Yep.
it's like, where to go?
It's, that's why I like PDFs now, F3, and start typing in.
Yeah, notice of intent filed after November 1st, 1987, that cumulatively alters up to 10% or 50 feet, whichever is less, of the length of the bank found to be significant to protection of wildlife habitat.
And then you have to comply with 310 CMR 1060,
Yep.
which is the wildlife habitat.
Right.
language.
Cutting to the chase, needs to do a wildlife habitat study? And then it's gonna drive the cover openness ratio in.
Yeah, I don't think it'll bump them into the next standard unless they say that
But it's a check mark.
there's deer habitat, coyote, you know, that could, but I don't, we're more concerned based off of what I've seen out there with smaller animals, but
Yep.
again, in order to be able to determine whether the project meets the standard.
There's plenty of deer out
Yeah,
there.
so.
Yeah.
We did. We actually presented the board with photos of.
We see them in our yard.
Yeah.
There's plenty of deer out there.
Okay, let's,
I don't think a driveway's gonna
Yeah, I
stay
have
around.
let's, you all set?
Yep, okay.
Ben, we're good. You want to go to butters?
Yeah, I will do. Just one thing, it's gonna have to be continued anyways,
Oh, I know.
but, if you could get, with that paper, that letter from the DPW thing for me, they're recommending planning and zoning, so I would get some verbiage from them people
Yep,
about the street opening,
Yep.
because that's a major factor in this
Right.
project. Yeah.
right.
Right?
No, I agree, and if we need some sort of a permit from them, we need to file for that.
Right,
Should be before we come here, so.
okay,
we'll get-
thank you, but I'm sure we're gonna have some butter input.
Yep.
Does anybody, would anybody like to speak?
So you have a choice. You can either sit at the table, or you can go to the podium. You just have to give us your name and address and go ahead and speak.
Well, my name is Patty Aloisi. I live at Village Green, and I'm actually going to, I just had a question about the wildlife study. What do we have to do, or what does he have to do? Like, how does that get performed?
He would hire a wetland scientist, and there is a standard on how to perform the study. I'm not a wetland scientist, but basically they're looking for signs of, the habitat area, places where little critters are living, invertebrate living, up to larger animals, passing through is one thing. If they determine it's a migration corridor or something, they'll note that in the study.
Okay.
And that kind of determines what sort of, the stream crossing standards are designed to allow for migration of animals and that sort of thing. And based off of what's seen out there, that's how you would accommodate.
So where they are in
Yeah,
where they live.
and having seen a deer doesn't mean,
No, I understand. Yeah.
but they could find a fox den or something like that, which would
Which
be
is
a
out
little
there.
different than, turtles and that sort of thing. So-
Okay, I understand. And one more question. So they were saying intermittent and perennial. So they determined that it was intermittent, which I don't believe that it is, but how did they get to that determination?
So the standards are, if it's shown on the USGS map as perennial, it's perennial. It was not, and they provided that information. The next step is a map, if it's not mapped as perennial, and you believe that you have greater than 1 square mile for a watershed area, or half a square mile.
So a mile.
It goes one or the other. So 1 square mile, they go into Stream Stats, which is a program, and they get the watershed area. This one was 0.06 square miles roughly. And then I think the next standard is that if you're greater than a half a square mile with a certain layer of unstratified drift, then there's a different set of standards based off of the probable flow. But with the watershed of 0.06 square miles, the odds of it being perennial are pretty small, and it's hard to overcome at that point in time that it's not intermittent.
So how does he redirect it? I don't.
That's square miles for the watershed area.
Right, that starts at Route 125, goes all the way around the whole complex.
They,
I mean, it's this deep.
the watershed though, it goes out to, was it Fox Hill Road or something like that we thought of originally, but it's a very narrow one. I mean, I don't think,
I actually went to the Registry of Deeds, and it is on a map from, I think it's like 1973, and it was called the Lennox Brook at one time. I don't know if that makes
yeah,
sense. But it actually goes through the whole complex, and it does start on Chickering Road. It goes underneath and
It's-
continues into Village Green.
the standard though is if it dries up for more than 4 days on an average non-drought year.
But it doesn't. That's what we're trying to show you, that it
No, I-
does not. It's,
See, I can see with my own eyes.
No,
Since this started, I go there every 2 days. That has not dried up. Even
it
in the
hasn't.
middle
We
of
have
August.
pictures, we actually have pictures of like the date and the
Can we
time.
just hold
and
on for a
everything.
sec, excuse me? The TV guy's waving to me.
Microphone.
Yeah.
Okay.
so,
As I asked you,
What do you need?
everybody that wants to speak can,
But they need to get.
but you gotta take a position in front of one of the
I
mics.
don't think the
And-
applicant should be, I don't know that we should be answering on behalf of the applicant really should be answering. But at the very first meeting, the question of the status of the brook
Yes.
was raised. And I made it very clear at that meeting is a brook may look like a brook, may look like a stream, may look like a river, but there is an analysis, a very simple analysis that is done. Just because you see water flowing, doesn't make it a brook. Just because you see it dry, doesn't mean it's not a brook.
quill, yeah.
So the instrument, the tool that's used is called Stream Stats. It's an analytical process. It's sterile, it's cold, it's based on topography, it's based on mapping, and based on a calculation that comes out of all of that. And when that calculation boils down, it tells you whether that's an intermittent stream or a perennial stream. That in hearing that everybody sees water flowing and sees, it's all anecdotal, it's all subjective information, not necessarily objective. The calculation's objective. It comes back, and we've done it on various parts of this brook before, downstream and upstream from this particular site, and we knew what the answer would be. It's gonna calculate out that it's not a brook. But we asked the applicant to do that because we knew it would be challenged. So he's done that, and we've reviewed that analysis, and it's accurate. It is not
I
a
know, but
perennial
he
stream.
himself is calling it wetlands, so how are they gonna redirect wetlands? Like, where does it go? It's, you
I don't think he's
redirect to
redirecting
where?
anything.
There's no
There's no
request,
redirection.
there's no request to redirect.
So I thought he said he wanted to redirect or fill
Restore.
something in. Or
They're gonna have to
So-
restore after if we approve it and they're allowed to cross it for purposes of construction, they're gonna have to restore the area.
So we're gonna let Ben come up and
That-
answer that one, because what we look at is the brook is going straight. The brook will continue to go straight. On either side of the span, where the footings go in to build the structure, there's some disturbance area. That disturbance has to be replaced somewhere. Perfect world should be replaced adjacent to and very near to the place that is actually being disturbed, and that's what he's proposing. And if you
Right.
show that on the map, that restoration area
Right.
adjacent to the culvert.
Yeah, it's right in this area right here. It shows, it's not shown in detail here.
You had it on another sheet, yeah.
Right,
Up
yeah,
behind.
Here's the details.
Right there.
right there. So that's the wetland replacement area. There's a planting plan.
But the brooks still go straight, no redirection.
Brook is still there. It's not redirected. It's just, it's gonna be temporarily, put a pipe in it, allow it to flow through while they put the utilities, and they'll take the pipe out and restore the brook itself. So the brook will stay. It's just some of the construction for the culverts will have to replace the wetland. I have to say too, we're disturbing 450 square feet. We're replacing 950 square feet. However, the area under the culvert will be replaced under the culvert, but we haven't taken credit for that. So there will be additional wetland buffer zone under that culvert, but because it's under the culvert and the shading effect, how much, how good a wetland is it gonna be? We haven't taken that area and called any of that restoration area, but it will be there, so there will be actually more than a 2-to-1 ratio of wetland replacement.
He's also taking down 50-year-old trees.
They're not jurisdictional.
I know, I understand.
Just so you know, the
I'm sorry.
calculations,
I'm
I'm just
sorry.
going to give you a citation. So 310 CMR 10.58, parentheses 2, deals with wetland, a stream, whether it's perennial or intermittent. And the standard, as has been said by everybody here, the standard is extremely hard. If it's not listed as a perennial stream, it's intermittent unless you can prove, and the standards to prove it are really astronomical. And it has to be done by a scientist with recorded witness data. And, so we're satisfied with that.
Okay.
I'm gonna take a look at it.
Well, use that, go to that citation in the CMR, that'll guide you to how to do it, so you don't waste your time.
Tell us who you are.
I'm Andrea. I live at Village Green. I'm also on the board. I'm the chairman on the board, actually, and I'm here to represent the board and our homeowners as well. A lot of topics were discussed tonight. A lot of my questions that I had were answered, and it seems like he has a lot of work to do still, so I won't go there. But my question now is the whole private way versus public way that was brought up. Since it has to go to the planning and zoning board now, and this whole bill kind of bypassed that because of previous laws, and it was, planned out years and years ago. If the decision of whether or not this is a public or private way has to go to the planning and zoning board, shouldn't we then consider possibly having this whole project go back to them then to approve it?
So I raised the question, and again, I raised it from the perspective that if there was a need of the town to better align the curve in Katuitt Street down at the bottom of the hill, not even on this project, but within the layout, this is the time to do that.
Right.
Public Works and Engineering have said that that's not within their
Right, I saw
jurisdiction.
that email.
So that email, that letter also went on to say that they recommend that we get something from the planning board
Right.
or the zoning board. Now, the reality is it'll never go to the zoning board because, as Anthony pointed out, is you get a denial from the building department. The building department says, look, I'm not gonna let you build your house because you have to build the roadway. They would appeal it to the zoning board of appeals. So it's not gonna ever get to the board of appeals till they go for a building permit. However, the planning office can make that call. So, Amy happens to work in the exact same department as all these things we just talked about. So, everybody in the department, I'm sure, is aware of this concern. Because if there is a requirement to do something in the curvature down there, it's simply going to change the alignment of the driveway. It's not gonna change the outcome of a project. It's just the way the project is carried out is what's gonna change.
So my other question then is to Ben, is are you putting in an additional driveway off of Lyden Street to your building?
No, we just.
No.
One
It's only-
driveway.
Only one driveway
There's
off
only
of
one
the two.
driveway is shown on this plan here. Comes off of,
Okay.
not the Lyden Street portion that accesses the apartments, it comes off of the Katuitt Street portion.
Okay, because on one of your plans, I saw that you wanted to put in an additional driveway, and you were waiting for DPW to approve that. And that driveway was coming off of Lyden, around the apartment complex and into the back. No? You're not doing that?
I mean, we did some study plans. I don't know,
There's been a lot of plans.
they weren't ever submitted to the town. If you've seen one, I'm not sure where you got it, but we did do a study at one time and felt it was, because there was more impact coming in that way.
Right.
So this was actually less impact, and that's what we decided to do.
Okay, all right, thank you. And the other one was what Anthony had brought up is does your driveway comply with the fire access road requirements? And that hasn't been determined. It hasn't, or the fire chief hasn't approved, I guess.
I don't think this kicks into the 20-foot axis. I think the fire department has to be able to get within 300 feet of the dwelling. And-
Yeah, so there's a couple of different standards. If you could just.
Right, I'll review that. I mean, I don't have that at the top of my head, but I have,
But now's the time to know if it does
Yep.
kick into 20 feet.
yep,
And if you have sprinklers in the house, you can cut that in half.
Yeah, that's the other thing.
correct,
Too.
correct. So we would add sprinklers if it did
Yeah.
kick
And-
into that.
And the fire chief has discretion as well, because it's, everything in the fire code is or at the discretion of the agency.
Exactly, yep.
But, like I said, these are things that need to be flushed out
Right.
now, rather than.
Okay. And, all right.
All set?
A lot of stuff was discussed tonight, I think. So, thank you very much.
Thank you.
Thank you.
Thank you.
Bye.
Hello, Eric O'Neill, 8 Kingston Street. I am in a butter. I just had a few questions. Number one, will there be markings for the do not disturb zone for the wetland and the restoration area, or is that required?
So,
Yes.
Amy, go ahead.
Yeah, it will be, and actually, the applicant's proposing a dry-laid fieldstone wall at the
Okay.
edge of the 25, and that will be monumented with markers as well. Yep.
And will there be a fence and any idea on the plantings inside the restoration zone?
Yeah, the restoration, replication area does have a planting plan. Fencing, Ben, refresh my memory on
We
fencing.
propose a landscape wall around the restoration area, and we'll also propose a fence along the property line, stockade fence,
Stockade fence.
Property line between subject property and the apartment?
in the apartments, right?
Okay.
Yep.
Okay, yeah, I saw that, yeah, it's called out, yep.
Okay, and my third question is, I have a sump pump in my basement which runs fairly frequently. I mean, it was running all day the past couple of days with the rain. And it actually empties out onto this property, which probably should not have been done in the first place, years ago when it was installed. So just curious as to, what the options would be there. I mean, there's not a lot of space to drop the water off, that property line being so tight.
So, I have sump pumps, and I'm responsible for them to daylight onto my property,
Okay.
not onto my neighbors. So you just have to find a way to do that. You have to find a way to daylight on your own property.
Is it that the pipe comes out on their physical property, or is it?
It
just
comes out
forward?
on their physical property in
So you gotta cut
in
it
that
back.
brush.
You just gotta cut it back and create a spreader for it. It's something that can be designed. Because you can't do it, I mean.
No, yeah, I
Whether they're
understand that.
proposing or not, you really.
No,
can't.
I totally understand that, I just,
I encourage you to, deal with the applicant to understand how that, maybe the two things can be coordinated together while, during construction, but I don't know where your unit is compared to this project. Are you an N unit in the one building, or is your building further, in border to the back of this lot? I don't know. But I recommend you just talk to the applicant's engineer and see if you guys can coordinate a discussion.
I concur. Well, just have a conversation and try to work it out.
very good, thank you.
Thanks.
We have any more butters? Okay, we need,
I have no question.
Just tell us who you are and have a
Ted
seat.
Deegan, Kingston Street.
Okay.
Does he have the proper amount of frontage? It doesn't seem that to me. I mean, he doesn't have a whole lot of frontage there.
There's a zoning table, if you could just scroll that picture down a little bit, it has the required frontage. This is a conforming lot. There's a, I can't read that. Frontage is 100, we have 100.
Oh, you got exactly 100.
Yep.
Yeah. Oh, convenient, all right. That's all I got.
all right, so we need to continue.
Yeah.
Before, I'm gonna move that we continue, but before I do that, I wanna make sure that Ben has his marching orders from us as to
Sure.
what he's got to do,
Yep,
so that we don't spend a lot of time
yep.
talking about the same thing twice that needs
Yep.
to be resolved.
So, wildlife habitat study, test pits, checking with planning, zoning on roadway
Fire department.
and fire department. Based on comments, just trying to get all of your numbers accurate
Mhm.
in the narrative, numbers for wetland replication
Yep.
to jive with the new plan.
Can I make a suggestion?
Yes,
Typically, in my experience on the commission, replication, we require 3-to-1, not 2-to-1. And we've conditioned 3-to-1 consistently during my tenure. And you'll probably hear the same thing from other commissioners. So
three,
I would,
sure?
I don't remember that.
I thought it was
Because I
two.
think the requirement is for 1-to-1, and we require 2-to-1,
Three.
and we've typically gotten more than that.
we've required 3-to-1 on a multitude of projects.
Okay,
So
You're almost there anyway.
without belaboring, without keeping this,
Well, if we-
we've already spent 50
Okay.
minutes
Underneath
on
the
this.
culvert,
You can add that in, you're
we'll add
damn
underneath
near
the
it.
culvert.
I'm gonna
back here.
suggest that you find a way to get more replication area.
Okay.
okay.
That's,
And before anybody, I'd like to have a continuance for a month. I
Yep.
think, do you have a second meeting in November, or does it go all the way to December?
So we have one meeting in November, which is
Right.
the 17th, and then we have one meeting in December, which is the 8th.
Let's go for the 8th then.
Okay.
I
No,
Okay.
want to
get-
give you time to review it, and there'll be,
Yeah.
it's a
so I'll move
complicated
that we
little.
continue to the December meeting.
Second.
All those in favor say aye.
Aye.
Opposed? That's unanimous. Thank you. Thank you, you butters. Okay, next one is gonna be a long one. 242-1826, 175 Old Cart Way.
This was a mess. I know, I saw that. I don't know what to do with it. That mix up.
Thank you.
All right, thank you. So this is a contingent public hearing in the matter of a notice of intent that we submitted for 175 Old Cart Way for construction of an in-ground swimming pool, associated decking, a small element of which is proposed within 100-foot buffer zone. At our prior hearing, we were hung up on the matter that there was an easement that was detailed on our site plan, and we wanted to vet whether or not we have authority to construct within that easement and what the easement is. We were advised to pursue legal consultation with the property attorney, which we've done. The property attorney had, now, my client, Mr. Patel, has had two property attorneys. His first property attorney reviewed the records of this proposed easement. It appears that it was an easement that was proposed or negotiated during subdevelopment of these lots by the original developer some 30 years ago, but the easement was never effectuated by the town. It was never recorded. There's no record of recording this easement. So now at this point, we've hired other legal counsel. With me tonight, we have Don Borenstein in representation of Mr. Patel. We believe at this point that the proposed easement is obsolete. It doesn't effectually serve the purpose that it was intended for originally, to provide access to a parcel of land, I think it was public land, that this isn't the only access to that property, that there's other frontage to roadways and access to the property. It's further complicated by the fact that what was originally detailed as Lot 8 on the property, which was Mr. Patel's neighbor, does not have an easement on it, so it won't afford the same easement. I believe Amy has had some communication with Town Council Suzanne Egan, as well as our legal counsel. So we return to you, I think now at this point, asking you, the commission, what you want to see to reconcile this, and we believe we have the right to construct in this area. So,
Thank you.
thanks.
Joe?
This is probably one of the worst planning town acceptance messes I've seen in a long time. Now, keep in mind, this subdivision goes back to 1987-ish.
Yeah.
I was only at college for 7 years at that point. Never mind old and ornery like I am now. The reality is, this roadway should never have been accepted. I believe it is. The mess that we're in and the lack of continuity of this access easement, which in fact was a very important thing to the town. We've done it in other places, abutting state lands and other projects. Should have been done. Should have been done back then. And I think one of the recommendations coming out of this is that, if we were to consider moving this forward, that, we now require the easement to be recorded. I'm not sure what good that does, because if we have a recorded easement, we can't even consider the project.
Right.
So we got this real catch-22.
Right.
I don't believe anybody in this room is at all responsible for what the heck has happened out here. This is a mess created by the town and by the prior developer, decades ago.
Right.
I think the state land hasn't changed. Access to it is an important thing. Should have been, still should be. Will it ever be? I think is what we're debating. And what we have here is a corridor that can be established from the roadway across two lots, Lot 7 and Lot 8, to that land. Both of which are now currently owned by probably not the first owner from since this was developed. It's probably multiple conveyances that have happened, never have been caught. I don't know what the hell to do, other than it seems unfair to exercise our rights in an easement, but I don't think recording anything at this point as to the easement does anybody any good. Because if we do that, how the hell can we then even consider the project?
Right.
There wasn't a question in there ever. That was all statements, but that's where I stand on this.
Yeah, I know. Right.
No, and I think we agree with your sentiments. That's our findings as well.
Jeff?
Yeah, I really don't know what to do either. The fact that the easement was never recorded, and it seems to be moot that it crosses other lots, that it's not really effective anyway. I really don't know what is legal to do here. So if it's not, if the easement's not recorded, does it actually exist?
Does not
No.
exist.
Subdivision plan is recorded.
So then, okay,
But
Showed on
the
that plan.
instrument that actually conveys that right, there is no instrument.
I believe they have their attorney here, and that's kind of gets to my question as well, is it looked like the deeds for each lot were by the plan, and maybe Attorney Bornstein can answer this. If you're deeded by a plan, and the plan shows the easement, even if the rights weren't granted, does the easement exist?
Good evening, Mr. Chairman, members of the commission. My name is Don Bornstein, an attorney with the Office of Johnson and Bornstein. Mr. Patel retained me approximately a week ago to help him with this issue regarding this proposed easement shown in the old subdivision plan. Like Joe, this question brought me down memory lane. I was on break for my freshman year of college when this order of conditions was issued, 35 years ago, 34 years ago. And if I had the mask off, you'd know. But the short answer to Mr. Cappuccetti's question is no. The reference to the plan alone does not create an easement. In fact, interestingly and ironically, the lead case on that was actually decided in North Andover. The plaintiff in that case was a Mr. Patel, not this Mr. Patel. It involved a very similar question here, and the Supreme Judicial Court of Massachusetts determined that reference to a plan that shows a proposed easement does not by itself create the easement. You need an instrument of grant to do that. I had a brief conversation with town council myself this morning. My understanding is she's aware of that. So I think it's very clear that there is no easement in effect here. We have an old plan that states proposed easement to the Commonwealth of Massachusetts. That easement was never granted. The order of conditions associated with this subdivision was never recorded. The planning board decision that approved that subdivision was never recorded. Again, walking down memory lane, this project began, it looked like in 1987. It never got off the ground until 1992 is when the planning board endorsed the subdivision plan. And for those who've been around a long time, we know what happened between 1987 and 1992. This subdivision also went through a bank on its way out to finally being sold to lot owners, including my client, Mr. Patel, who's the fourth owner of the completed house, the eighth owner of this property since the subdivision plan was created. So this is an interesting question, a 34-year-old question, but it has an easy answer, which is there's no easement. There's no ability to enforce that easement against the lot owners, and under the law, and under fairness, I think we've heard that statement already. How can you hold an unrecorded easement against a lot owner 34 years later who just wants to put a pool in his backyard? And when that easement itself wouldn't do anything. Now, this state land, part of the Harold Parker State Park, it does have other access to it. It does have significant public way frontage. There are actually other lots in the adjoining subdivision, sort of the sister subdivision to this Colonial Drive, that does still have open parcels associated with it. I don't know what the history of that is. I dug into this history fairly deep. That neighboring subdivision may have its own history. There might be access opportunities, and in fact, the spot where this easement was proposed seems like the most impractical spot because it's actually the longest distance between open space to the south and the Harold Parker State Forest to the north. So I'm not sure why it was there to begin with. But the short answer is there's no easement, and it's hard to hold that against a lot owner today.
Let me ask you a question, if I may. On Mr. Patel's deed, is there any reference to an easement on the deed?
There is not.
In a title search to Mr. Patel's property, was there ever a reference to the easement on any of the deeds for the preceding owners dating back to 1987?
I haven't done a title exam myself. I've relied on his title attorney's exam.
And what's the answer?
And I think that answer is no. As I've reviewed it, I think that answer is no.
So a title search doesn't show an easement?
Correct. This easement has not been granted as it was apparently proposed.
And as such, was never recorded on his deed or any of the accompanying deeds in the subdivision, is that
Yeah, I would refer to the letter that's already in the commission's file from the title attorney, who states very clearly, unequivocally, that there has been no grant of this easement throughout the title chain of this
Wants to-
property.
Just by reference of the plan, which references the easement, that, there is that parallel reference.
Yes, we talked about that.
The deed
when I-
refers to the plan refers to the easement, easement doesn't exist.
Yes, and that's the point that I made when I first.
Well, that's the
took
reason I'm
podium.
asking about deeds and title searches, because experience is sometimes the best teacher. And I'm a person who has a deed that has an easement on it over the property of another. And that easement was listed on the deed as an item and recorded, and then taken from the deed and put on the plan of land for the town parcel and for my own in the survey. So that's the reason if I appear to be asking the same question 15 times, that's the reason why I'm wanting to know about previous deeds and previous title searches, perhaps to see if it was never there, that's the answer. But if it was ever there at any point, when and where did it fall off and how?
Yeah, I don't think there's any falling off. I think that the interesting question is, does the fact that a plan is referenced, because of course the subdivision plan is referenced throughout the chain of title since the subdivision plan was recorded, as you'd expect. But the interesting question is the reference to a plan that itself shows a proposed easement, does that create the easement?
Well, isn't that how you create a description on a deed? Don't you create a description on a deed from a survey plan showing the distances? When I read a deed and I see it has so many feet this way, by so many feet this way, by so many feet this way over the land of so-and-so, I mean, that's how the description is created, yes?
That sounds like an accurate description of a description.
And
But as far as.
where the data comes from has to come from a plan somewhere. The attorney describing the deed for recording for the client doesn't just pull the numbers out of the sky. That attorney would have a document somewhere to refer to, which is usually listed on the deed.
Yeah, that would be a running deed. Sometimes, like, I looked up this deed
Yeah.
and it just refers to Lot 8 as shown on the plan with all easements, covenants, and.
I know, I guess I'm just hung up on where this went bad, because I'm willing to bet that at some point, somewhere, somehow, a description was created from the plan that called that out.
Well, I think what that Patel case that I mentioned, and I've brought copies, I can leave them with the commission, I'm happy to do that, it's something you might want to have available anyhow.
Okay?
That's Patel versus Planning Board of North Andover, and it's a 27 Mass Appeals Court 477, it was decided in 1989. In that case, very specifically, in that situation, they had a subdivision that had an easement left over to actually access adjoining land, and there was an easement proposed on that plan. That easement was never affirmatively granted. My office actually represented the ultimate owner of the abutting property who wanted to use that easement. And we were successful in front of the town and in the lower courts in establishing that the mere reference to the plan should have granted the easement. The appeals court actually reversed that. I think I'm glad to say my office didn't handle the appeal. But the appeals court reversed that and found that the mere reference to the plan itself did not create the easement, that there had to have been an affirmative grant. So the thing to do here is you probably see in other projects where you condition an easement, that you have to get an easement document. You get an easement deed, you put it on record. It's an easy thing.
Which is a deed, right?
Yes.
The affirmative granting document is the deed.
Yes, it would be an easement deed, or you could have a explicit reservation in the
That's why I keep asking the
deed.
same question.
Yeah.
Back 30 years of transactions, how many times the lot's been sold? At any point, did any deed reference that easement? I don't think we have an answer to that.
I'm not sure it matters.
Huh?
I'm not sure that matters.
Oh, certainly it does.
Well, we don't have the
I mean,
physical.
I've been operating on the premise that this is an accepted public way, Olcott Way. I don't think it's not. I don't think they ever didn't come to town meeting and get accepted. I think it is accepted. So if any of those requirements, building things to standards, recording documents, having instruments in place, even the deed that conveys the roadway to the town, all those things have to happen before a roadway gets accepted in Massachusetts, in most towns and cities across the country. If there was a question of where is the easement, it should have been asked then.
And we've all been to town meeting, and we've all seen roadways get rammed through in the 11th hour to get accepted because we're running out of time. I don't have all that confidence in the
Yeah,
world.
again,
in granting
but I think, I'm going to use the phrase fairness, but if the town had an issue with it,
So,
the time to have raised it before you accept it, when you accept it, you'd say, we're satisfied with the outcome of this development. You bring it to the town voters and they raise their hands. Once that's raised, and if we don't have an easement and someone raises it 30 years later like us,
so.
I don't think it's fair.
So this fell off the rails at some point in history at the hands of someone who worked for the town.
Almost certainly.
I
mean, no denying it.
without any doubt at all. So how do I have that confidence in the same person that's standing up in front of me at town meeting when this type of mistake has happened? And it has. That's the reason I'm asking the
beauty of
question.
our government, we have
I'm
faith
trying
in
to, I'm
government.
trying to get a level of comfort, because I understand and I know probably exactly how this happened. Because I came on this commission in 1991.
Mhm.
So, I know exactly.
So that last tirade I just went on, it was all on the premise, this is an accepted public way, is that if this has never been accepted, if this roadway doesn't legally exist in the town's list of streets, then I guess the issue is very much still open, because if it ever, I mean, there's a lot of unaccepted ways, but if it ever does get accepted, then someone's gonna have to say, it'll never be accepted because it was never recorded properly.
And I'm just trying to get a comfort level with what you're telling me. I don't, for one second, not believe what you're telling me. I'm just asking for a thorough document for our record so that we can have confidence in our vote, and so that when this thing maybe gets brought up again sometime in the future, there's some clear record of what happened. I don't not believe anybody here. I just like to know where things fall off. I'm a little fastidious sometimes. I apologize.
I've noticed that.
Yeah, I know. Well, you and I have done this before.
Yes. And I think you have that, Mr. Manzi. I think you have a letter from Attorney Timothy Doyle
Okay.
in your record. It's dated October 8th, 2021. And he says very explicitly that he has conducted research into the easement shown on Plan 12029, which is the subdivision plan. And he's searched for the above referenced property and the abutting parcels going back to the creation of the subdivision. We did not locate a recorded grant or reservation of easement during our inquiry. So I think
I
you've got.
don't have that, but
Yeah, we
Pat's
didn't get
getting
that. Thank you. We had town council.
So that's the attorney who did the title examination for Mr. Patel. I believe he was Mr. Patel's closing attorney when he purchased the lot 10 years ago. And I think Mr. Patel asked him to go back through his records and go back through the register of deeds, and this is the letter that he produced for the commission. So I think you have that
so
information.
we believe that this document answers my question as to going back in time.
Yes.
Yes.
Okay. I'm
So,
satisfied.
So if we're satisfied with the data the backup we've been receiving, I guess reining it back into the application that's before us is, any reference to a 30-foot wide access easement should not be shown on this NOI plan. Because it only adds confusion. If it doesn't exist, it shouldn't be shown on this plan. And if it is shown on this plan because there's some question whether it exists, then the application is not approvable.
Well, I mean,
There's
again,
there's the line, it's right there.
yeah, and, you know, as we go back in history, the names we see make it very understandable as to what happened. Okay. Sorry,
I haven't seen those names yet.
well,
I wouldn't be surprised. I know the era.
You called them the names, and you don't even,
I'm satisfied with your assertion. I'm all set.
okay. This is a catch-22, which I really don't, I'm not a lawyer. The problem is, even if we fight for the easement for Lot 7, we still gotta deal with Lot 8 to get to the state land. So, I mean, we're kind of like chasing our tail here. And like you say, this lot has been developed 30 years, right? 30 years, I believe. I mean, I don't have a problem making it go away. Like you said, there's other access points to the land. I don't know, I don't know if legal, if we can do it, but that's my opinion. I think that.
Well, we can accept the evidence of the title attorney. And by accepting the evidence submitted of the title attorney, that, in my opinion, cures the issue. Because his testimony before us is that he did a thorough title search and went back in time, which is what I asked for.
Okay.
That evidence submitted and annexed to the application of Mr. Patel, in my humble opinion, should be sufficient.
That works.
I don't know if anybody disagrees with me or
No,
not.
I agree with the decision I think we've all reached here. I think to make this right with regard to the notices before us, is strike from the plan any reference to the easement and get that easement line off of here. Is for us to have to dance around it in an order of conditions that says,
Well, that would require just a resubmitting the.
just change the plan. Take,
A new record
turn the
drawing.
light,
It
the
would
line
require
off
a
and the
new
note
record
off.
drawing
It doesn't show.
that doesn't show an easement.
We're happy to amend the plans.
And make sure the title search with the history is annexed and everything is attached there too.
We can cite reference on the actual plan itself.
That would make reference to everything.
Yeah, agreed. Okay, that's easy to reconcile. Yep, we can do that.
So at the last hearing, the commission asked for elevations need to be more legible on the plan. The project requires a larger stockpile, construction access, and cross-section of the wall detail. I don't know if we
So,
have those yet.
so if now we're beyond the easement and moving back into the civil area construction, that's where I can give a presentation. I did print some full-size plans. I know that you guys said that the 11 by 17 wasn't very legible for you guys last hearing, so I just printed a few of these if you wanted to have full-size plat references. I don't know if you can project the.
All right, so we have to continue anyways. So what we're gonna need is a revised set of plans showing
Yeah, I don't
that.
have those electronically.
What, I'm sorry?
I don't have that plan electronically.
Oh, I emailed it to you in PDF format.
You want this one?
When I sent the attorney letter, I sent the revised
Oh, you did?
site plan. Yeah, it should be.
Okay.
Well, we understand that we have to continue to revise the site plan and get that back to you prior to the next hearing, but I was hoping to address just some of the civil questions that you guys had at the last hearing. And I think some of those questions were the height of the wall, the detail of that retaining wall, that at the scale it was drawn, that there was some question as to the height of that wall. And we discussed that the civil engineer can only detail a wall up to 4 feet, at which point a structural engineer needs to become involved. So we did provide just a cross-sectional detail of what the retaining wall is. This plan, as the last plan was stamped by a professional land surveyor. This was actually reviewed and stamped by a registered civil engineer, Joe Pesnola. He's our director of engineering. The maximum height of the wall, we did carry a detail in there. It's less than 4 feet. I think it's 3.6 at its greatest height, which is at one corner. And that's the detail on the wall. The contours, the grading contours, they did revise those slightly to accommodate for this. We do have a planting and stabilization plan. What I think was misread as boulders on there were actually planting specs for sweet pepper bush. We had previously had non-native ornamental shrubs. That was one of the initial comments in Amy's review was can we put native species in the buffer zone? And we can, so we've revised that. We have detailed a larger stockpile area. It is located on the driveway outside of the 100-foot buffer zone. Our primary construction access to the site will subsequently be that driveway as well. With that, I think we've answered most of the questions that you guys had, and I'd be happy to answer any other questions or any other revisions or details you'd like to see in our final revised plan set.
John, do you have any questions?
No, my big thing was getting the easement off if it doesn't exist, and I think we've beaten that one to death, so.
Thank you, Tom.
I only, this is only one other question. We don't even know if there's any outstanding order for the original order, correct?
There is an order that we have in the file, but it never,
This is
for the
subdivision?
subdivision, yeah.
No, the lots were done as part of the subdivision, or they come in individually? Actually, when the house
Nothing
was,
came in.
no, when
I
the
mean,
house was built, they were probably outside the 100.
Yeah, I would say
Yeah.
that this house definitely, yes. But there's no subsequent applications for the house lots.
Well, Louis, I'm asking, because if there was any outstanding orders, we couldn't approve this.
Well, I can tell you,
Until-
looking at the signatures that were signed in 1987 by the commission members at that time, the policy back then, because I came on right after this, was the subdivision was filed by the builder, and the house lots were all part of the subdivision filing
Yeah.
plan. They were not individual filings. His house could not possibly have an individual order of
Yeah.
conditions on it.
Right.
It would have come under whatever order of conditions was for the subdivision. There's no question that's the way it was done at that time.
Yep.
No question
Okay.
about it. So
Okay.
you won't find anything.
All right, so we need to continue till the next meeting. Does that work for you?
So I want to request, so only now, looking at what you guys are thinking, it's just we need to update the plan. Can we do it off the hearing, and can we submit it to Amy with the new updated plan, and can we get approved? Instead of pushing it for the next hearing. Is it possible to just submit the new plan without the
It'd be the same
easement?
outcome if we were
It
to,
would.
if we were to continue, we would issue a decision at the next meeting.
Okay,
If we-
cannot be signed
If we
off.
continue, and if we close, you'd get a decision at the
Well-
next meeting.
Provided that everything is received at the office, that everything that we've asked for.
Yep.
Then Amy could prepare a draft decision that would be considered at the next meeting. It would be closed and issued in the same night.
Thank you. I understand that, and I appreciate that offering, because that won't result in any longer delay if they draft the order of
You
conditions.
just gotta do
prior
a
to-
good,
Same outcome.
you gotta do a
I
good
can
job
have it
getting the
early.
stuff to her,
On the second.
because she'll make that decision.
We can flip this in 48 hours. Yep, yep, no problem.
Yeah, that works.
All right, so we need a motion to continue.
So moved.
All those in
Thank you.
favor say aye.
Aye.
Opposed? That's unanimous.
Great, thank you very much for your time.
Thank
Much
you.
And that's
appreciated.
Thank you.
November 17th.
Thank you.
Thank you for your time.
Thank you, councilors.
The next one is 242-1827, but we have an enforcement order we have to clear up first.
Yeah, so let's take
So
them,
let's
take
go
them
to
together.
enforcement orders
Something's
for 60 Campbell Road.
What's up,
We're gonna review the enforcement of the 60 Campbell Road, because we had some questions about a wall and what we wanted them to do on the slope and before we could approve the NOI.
Alrighty. Okay. So the commission will recall last meeting that we wanted to wait for Natural Heritage to chime in. They have chimed in, it's a no-take, so we're off the hook for that. Commission charged me with drafting up an enforcement order that would allow them to start work on restoring the slope. I've done that. And they have submitted a revised plan that has enhanced buffer zone plantings on the slope, that has met with Taylor's approval. He has made recommendations for seed mixes that should be used with possible amendments. As far as a barrier at the top of the slope, at the last meeting, the commission gave guidance that whatever barrier that they're going to propose should be physical barrier from entering that area, but also provide visibility that would make dumping an eyesore for the homeowner to observe. So they've come forth with the post and rail fence. So that's it in a nutshell. And if you wanted to walk through my draft enforcement order, we can do that. Or if you have questions.
Yeah, So the barrier was part of the enforcement order? Or part of the NOI?
I thought it was the enforcement order, but
Okay.
it can be whatever you guys want it to be.
Well, because I want to discuss it, so I don't want to discuss it for the enforcement order.
Okay, yeah, yeah,
If it's part of the NOI.
yeah.
Joe?
So I have no questions. I think within the context of what's being proposed, I think the fence does make more sense than a wall. I'm not saying that just because Sean's not here, but I think in this proposal, it does make sense to have a post and rail fence. As a
You have a
matter.
hard time selling me. Jack?
Yeah, I have no issue with the enforcement order compliance. I would go for something more than a post and rail fence. I think in the past, we've preferred the dry set stone wall at the 25. This is actually inside the 25. We've allowed chain link fences, which I think also serve the same purpose, but that's really my only comment. Other than that, I think they've complied with what we've asked for.
If we're gonna go away from the stone wall, which I'm not saying I object to, I do not approve of a post and rail. That's just too, you've dumbed it down too far. Some type of a steel fence. The intent is to provide a permanent barrier. A post and rail fence can be disassembled by a 12-year-old in about 15 minutes. It's gotta be better than that. And that's just my take on it.
Okay. Myself, I'm still adamant about a stone wall. First of all, I know the applicant didn't do it on purpose, but once a violation has been caused, I kind of lean toward a stone wall. It's more permanent. Plus, if you ever decide to sell a property, the wall will be there with the plackets. And then we had another issue. He kind of even went on the other guy's property on the side, and we kind of like, I don't know if we were ignoring that or not. That's, I mean, it's good that the neighbor didn't complain, but it just shows that, you know, do what you want. I think the wall should go from the end of the driveway to the far corner where the tree line is. That's my take on it. Tony?
I missed the last meeting, but I did watch the video. I kind of got the impression that we wanted something that you could see through, so you could keep an eye on the dumping, but that was, you know, kind of how I took it in. So I think they've tried, but, you know, the commission standard is a stone wall. I don't disagree with being consistent, but I don't fault them for what they've proposed. I think that.
If I may, the idea was that this area is obviously outside of the 25 foot. In some cases, it's almost 50 feet where the stone wall is being asked for. So the homeowner is concerned about the cost of this. You know, he's a new homeowner, first-time homeowner, who's concerned about hiring an outside professional to do this work. And, you know, I understand your point about not being a permanent barrier, but, you know, maybe there's a way to incorporate some kind of section of stone, perhaps closer to the 25, but these are areas well outside the 25 and some portions that, you know, your commission is asking for a barrier.
Would a condition in the order that's recorded that says that the fence needs to be maintained in perpetuity or modification needs to be sought from the commission? I mean, be something that's.
I try to be consistent. I know this commission rests their hat on being consistent. We've made numerous applicants do stone walls, and financial difficulty is not one of the issues of, we got a slope, we've got a violation, we got a violation on going over somebody else's property. I'm sorry, I mean, and I'm trying to be consistent. If you were applying, I'd be asking you the same question. And like I said, post a real fence, you might as well just put nothing. So, and I don't think that, I know we say a loose stone wall. I don't think it's as expensive as the applicant thinks. It's not a masonry wall. It's just stones laid down and laid on top of each other across the whole perimeter. I don't think it's the expense that he thinks it is.
The applicant has already proposed a short boulder wall along the driveway. Maybe a good middle ground would be to extend that to replace the proposed post and rail fence.
So, excuse me,
Yes.
if I can interject. The issue I'm having with the stone wall, and so my profession, I specialize in retaining walls, certified by the National Concrete and Masonry Association, and adding that type of tonnage to the top of a slope like that isn't in anybody's best interest for the stabilization of that slope. Adding that kind of weight decreases the global plane of stability of that slope, and as the homeowner, I would incur any damages that happen with that slope sliding at that point. So that's why I proposed the post and rail, because it was a lighter option, but still catering to the barriers requested by the commission. So if possible, if rocks are what is deemed permanent or steel, can we do post and rail with boulders kind of intermittent as a permanent yet subtle looking post and rail, but also eliminates the stability issue caused by a large stone wall? With more plantings, hemlocks, native plants, just to make it look as natural as possible.
Like I said, I mean, the 2-foot long, loose fit stone wall, I don't think it carries as much weight as you think it does, versus, filling it with mortar and reinforcing it. Like putting a 3-ton boulder in an area and then putting one next, 5 feet away, I think is gonna be more weight bearing than the stone wall. And the post and rail fence, unless you wanna do it for aesthetics, that's fine, but as far as the commissioners goes, it doesn't fly for us as a protector of the wetlands, correct?
Yeah, I agree.
Would you do a granite post with wooden rail?
I don't think it's the ears on the rails itself that
They
slide.
Yeah.
But I mean, by design, the farmers made them that way so they would in fact be able to
But
get
kind of
across
like-
it easily
yeah.
with carts. So
Right.
yeah, we don't want any sort of rail. So my initial premise was when I said in context of the site, is that the 25-foot no disturb is pretty far down the slope of this. We would typically require it at the 25. So it's not practical to put it there. The fact that the top, there's a clear break in topography out here, backyard, 10-foot slope, down to the lower area. I think that at the closest point of that flat yard area, we're looking on the order of 5-6 feet to the 25. So we're getting something closer to 30-foot no disturb at the minimum. In many instances, we're getting close to 35, 40 feet of no disturb. So I think a fence is in this context does make some sense. I don't think we're getting anything out of a wall on this.
To your
But-
point, could we do a wall where it is close, let's say within 35 feet, and then post and rail on the sections that are outside
My
of
colleagues
that?
have talked me out of post and rail, but that's off the table, I think.
Okay.
I tried.
You said fence, I didn't know where you were
know how to-
going with
I don't know
that.
how to put
I
that in a
started
better way.
this tobacco on the post and rail by opening the crack, and unfortunately, that door was slammed in my face, and I agree with my colleagues. It would be a heck of a relaxation. But I think a fence at the top of the slope here is a legitimate thing. So what does that fence look like? We want something substantial. We want something that doesn't have gates. So, it can be an ornamental vinyl, it can be ornamental iron,
Vertical steel.
vertical
black iron.
Yeah, there's a whole bunch of stuff you can do,
If-
cheaper than a wall, for that matter.
If that's the case, I'll cater to the original plans of the stone wall for the commission.
To the wall?
Yep.
Okay.
Now, just a New England stone wall, correct? Like,
dry set.
Doesn't have to be a certain dimension,
We have,
but
no, we have,
Two
we have a
by two.
cross-section, we have a picture of a cross-section, which, that's what you should follow.
The consultant that you hired
Because we've
knows
done-
what our stone wall looks like.
2 by 2.
No, but here's the trouble, we're gonna show you a cross-section, because we've done this before, and we ended up with 300 feet of pea stone once. Okay, so,
that won't be the case.
you know, we've already been burned on this, we have a cross-section of what we want the wall to look like. If we could take pictures,
So, we have, Williams and Sprage has provided a cross-section of the wall for 292 Candlestick. So,
We just need that detail shown on the
Sure.
stone.
that
That's all.
detail needs to be shown.
Yeah, and like I said, I know you're saying that if you put it up top, at the crest of the hill, he'd be losing some of his 50 to 25, but putting it down to 20 feet, it's going down the slope, it wouldn't be accessible anyways.
He's got that all planted anyway.
It's all,
Yeah.
it's gonna work out fine.
Yeah.
Yeah, where he's proposing to put it, as long as the
Right.
wall's going.
To be clear, I just want to take the path of least resistance to make this correct for everybody at this point.
We're trying to
so-
do the same thing with you, we're trying to help you.
So, stone wall's good with me.
So stone wall's good, okay, that's fine. So we're looking at the,
We would just amend H on the enforcement order? No, was it H? Or was it? Yes, H.
okay,
H references a posting rail, so we can just change that to
okay, so to the motion.
So, I would like to add, I forgot to add overall survivorship of 75% for the plantings on the slope. Add that.
timetable on those two growing seasons?
2 growing season, yes.
So
Um,
you're adding that to the EO?
Yes.
Okay,
I didn't,
so I'll move the EO as amended.
the only thing I didn't do is put like a deadline of actually getting the plants in, because should we, I mean, I don't know what the reality is for this season.
Right. I think the idea is that, Tate's ready to start this and amend the issues as fast as possible, but we don't know what the weather is going to do in the next few weeks, months.
You can still plant now.
Right now, probably, yeah, maybe not today,
You might not
but,
germinate seed very well, but you can plant.
right, so,
They're going to sleep anyway.
right, so but there's a significant amount of work needs to be done
to get
before
it.
planting occurs. And then the risk is some of these plants don't take and they die die during the growing season in the early spring, and then he has to replant everything again. There's a route to potentially removing the fill and stabilizing things for winter, planting in the spring when we know things will have a better chance of survival.
So I think the way we leave this door open
It's
is
worst
that we,
case scenario.
we require that the slopes be stabilized and maintain stability through the winter months.
Yeah, all erosion
And that
controls
once
would be.
planted, the clock begins to tick for the 2 growing seasons.
Okay.
That if they do it now and it's successful, great. If not, they stabilize it through the winter, they plant in the spring.
All right.
Planted before June 1st, 2022?
Sure.
Yeah. Hopefully April if weather
Yeah.
allows.
Yeah, no, but
you
yeah,
wanna
just to
plant
give
it
you some
as soon
breathing
as
room.
possible, yes.
And then maintain stabilized conditions throughout the winter.
And then as far as seed, is that on Taylor's recommendation?
Yeah, so I did, I added what he emailed to Thor.
Perfect.
Yep.
All right, do we need a motion?
We have a motion, but do you want to modify the motion as modified?
As amended.
Second.
All those in favor say aye.
Aye.
Opposed, and that's unanimous. Thank you, that's.
Thank you
You
for
might-
the
you
time.
might just- You might as well just stay right there.
Yeah, stay there.
Next one is the.
This is also the, this now becomes the NOI or
No.
separate
Have an
document?
enforcement order to start work on the slope only. Anything that involves restoring that slope, this is what your green light is. So the rest of the amenities that you're talking about for the notice of intent would, be dealt with under the order of conditions.
So we continue the NOI?
Well, I
don't
think we have to, only because I haven't drafted a decision, but if you guys, I think we should at least look at what the proposal is for the rest of what he wants to do, make sure you're comfortable with that, and then in the meantime, I will draft a decision for the 17th, and then we can close and issue.
So the only thing I would add to the drawing would be all those things we just discussed.
Yeah.
So they'd be depicted on the drawing.
Yes,
Including the wall detail.
Yeah.
yes.
All right, do we need the wall detail and the wall on the plan.
And is Taylor okay with Hosta? With the planting?
He didn't, I think it's far enough out.
All right.
It's not, up close.
So you sure you're okay with Hosta? I fight it every year in my backyard.
The only problem is it's like 100% shade, so it's the only thing I know.
Well, that's,
about
oh, yeah.
So with an offending order, offending party, the enforcement order is binding upon them. They really probably shouldn't even go with the abutter, but under an NOI, we're about to issue a decision that records actions on someone else's property. We need something from the abutter
Yeah, I took the
that
words right
says,
out of my mouth.
So we did.
Do you have that?
We did supply Amy with the signed WPA Form
Okay.
3.
We
from
do
the-
have
I
that.
forgot.
No, that's
Um,
okay, no, we have it.
Yeah, and she's on board with everything that Tate's doing. It's really in the very back of her property. There's a thick wooded area between that area and her home, which is way out back. So they never even see this area. And the stone wall that you see at the toe of the slope, that's what everybody thought the property line was until we did a survey of the property, and it wasn't.
Okay, so we need to continue.
So moved. Second.
All those in favor say aye.
Aye.
Opposed, and that's unanimous. Thank you.
For the time. Have a good night.
Thanks, guys.
Good
Thank
night.
you.
At this rate, we're gonna be here till 3
No,
o'clock in the
no,
morning.
no, we're not.
I'm gonna start moving things very quickly.
24, no, we're through the tough stuff. 242, 1830, 1101 Turnpike Street. Due to time constraints, I think we should do Amy's
Okay, yeah.
recommendations, and then we'll, if we need any questions from you guys, we'll,
Sure.
huh? Because this should be a slam dunk.
Is this the first read of this, or is this continued from prior meetings?
No, first opening.
This is no,
So all I have is the narrative, I don't have the NOI. Enough that.
Yeah, I know.
Okay.
I didn't give, I mean, I emailed it to you, but I didn't print it out.
Thank you.
Okay. All right, great, thank you. Okay. All right, so this is a proposal for an 8-bay, 102 by 30 pole barn, proposed on existing parking lot. The proposed work is located outside of 25 and just outside the 50, and portions of the proposed work lie within the outer limits of a 200-foot riverfront area of an unnamed stream that's tributary to Boston Brook. Closest point is 55 feet to the BBW. The building is going to be supported by 24 4x4 footings, and those will be saw cut into the pavement for installation. Our field inspector visited the site, agrees with the delineation, and notes that the topography behind the building slopes up before you get to the wetland, so we have a little protection there. We have a revised plan that shows a stockpile area outside the 100-foot buffer zone. So this, I said close and issue in 21 days, but we can't do that. We need to continue, and I need to draft a decision for the 17th, because it's 3 weeks.
so what they're trying, they're gonna saw cut the foundation, the parking lot, so they can put the footings in on an existing parking lot. So there's no more, there shouldn't be any more disturbance than there is now.
So the question that I was gonna raise, and I think we should consider, we should ask the applicant while they're here before us. So the parking lot's relatively flat, and the pole barn is steeper shed roof, concentrating that flow to the back of the building closest, the area closest to the wetland. So I think some sort of a gutter and downspout system across the rear shed of this be established, or a drip line and some sort of infiltration to control that runoff. Yeah, some sort of, yeah, and get it into the ground before it's sheet flow.
I thought that too, and then I kind of said on the flip side, you'd have vehicles parked there that they'd be pulling oil off of versus now you're gonna have them covered and protected, so it's a trade-off, I guess. So, but yeah, I think if they could accommodate that, that would be better.
Yeah.
Yeah, I would agree with that, that the runoff is potentially something that would need to be managed as part of the runoff from this roof. Looks like no waivers are requested. It looks like, okay, is the interior of the pole barn going to remain paved as it is now?
Yes.
Okay. And, yeah, I have no other questions.
Yeah?
Nope, I agree with the capturing the rainwater, capturing your runoff. That's a big ticket item, I think. Everything else looks good. All set.
So now all you're gonna do is patch around the holes after with pavement, right? You're gonna leave the existing pavement there, you're gonna leave the existing pavement in.
Jetting up from the footings.
Right, so you're gonna do all handwork around.
Yep.
Okay. We're gonna continue anyway, so we're gonna take another look at the plan anyways. Okay, motion to continue?
So move.
All those in favor say aye.
Aye.
Opposed, next, see you in 2 weeks.
We only have one meeting in November, and we only have one meeting in December. Okay, guys? There's only one in November, one in December, so.
Thank you.
Thank you.
So the plan, you'll come back with a plan that shows a method to capture that roof
We'll
runoff?
have a drip edge or something. and
Okay.
then we should say
Okay.
who we are. Sorry, Mike Mulaney, Mackenzie Engineering.
Mike Toohill from Conoco Engineers and Scientists, here from Essex.
It's
You guys know what to
probably a
do.
good idea.
Yeah, it's just, that not that we don't wanna hear from you, we just don't wanna hear from you. Thank you.
Thank you.
Thank you very much.
Okay.
So,
I'll see you in a few minutes.
yeah.
All right, next one is, RDA for
Oh,
326
yes, thank you, thank you.
Campbell.
Campbell Road.
Here, Mike.
326 Campbell Road.
326 Campbell, all right, let me grab that plan. All right. Okay, so the commission will recall issuing a certificate of compliance recently for this project. It was a tear down rebuild. The wetland in the back was determined not to be ephemeral, so we have a regular 25 and 50. The new homeowner is before you tonight to extend the driveway and install a 14 by 14 gravel shed pad. All of this is out of the 50. And within pretty much what's lawn right now. So the driveway expansion is 19 by 40, and the gravel pad for the shed that will eventually be placed there is 14 by 14, and any new shed that would be installed there would not exceed those dimensions. So this is, and it's all out of 50.
Okay. Joe?
So on the drawing, there's a reference line that shows 75 foot to some sort of undefined line. That was under the assumption it was ephemeral?
That's-
So
Yes.
we should strike that from the drawing?
Yeah,
Or
okay.
or at least make reference to what
Yep.
we're about to do that line doesn't mean anything.
Okay.
Is the 50 shown there on the chart? Actually, the 25 and 50, I don't see on this.
The markers, the no disturb zone markers are at the 50.
And that's from the old certificate
That
of
was the
compliance.
50 no disturb zone when we thought it was a vernal pool.
So we can come up with words of that on anything we're about
Yes,
to put out.
absolutely,
Almost set.
yeah.
Jack?
And I noted that on the certificate of compliance as well.
Okay, good.
What's the intent for that green area that's shown within?
That, so when they raised the existing dwelling to put the new house up, they actually went into the 50-foot no disturb zone. So that line actually kind of shows, based on the mortgage plot, where the actual 50-foot line is. So the rest of the yard comes up to that 50-foot. You've got weeds and grass, but there is that small section that's been cleared out already. So just pointing out that the gravel pad won't be in past that 50-foot line.
So what will be there?
It's just grass right now. There won't be anything there.
Manicured lawn?
Yeah, it's manicured lawn right now,
No
currently.
other questions?
Yeah?
All set.
Tom?
No questions?
Motion?
So I recommended issuing a -3 with conditions that required erosion control installation, pre-construction meeting, all materials to be taken off-site, and a post-construction to verify compliance, which is standard.
Second.
All those in favor say aye.
Aye.
Opposed, and that's unanimous. Thank you.
All right.
All right, so I'll get that permit to you, hopefully, if not this week, early next.
Okay, thank you.
Okay, thanks.
Next one is the Glenny Woodlot Town Farm Boardwalk.
Okay, so, that's not what I want. All right, so Friends of North Andover Trails is before you for a proposed boardwalk to connect the newly acquired Glenny Woodlot open space parcel to the town farm land over a narrow section of intermittent stream. I'm trying to just find a good picture of this. So this map shows kind of the location. So the construction of the boardwalk is typical of what FONET has done in the past with the pan footings. You know, they have photos of, this is the actual crossing, it's the narrow spot. There's lead-ins, and then Commission's familiar with this type of construction. I've walked it, Taylor's walked it, so we're familiar, and this makes sense in terms of its location. So if the Commission has questions based on that, then I have other stuff I have to talk to you about.
Okay. Joe?
First and foremost, you guys are great. Love the work you do, and thank you for that. This particular, you guys are aware of this, we have some vulnerabilities with ATVs and off-road vehicles in some of our properties out in this neighborhood area. So I'm hoping that as part of this proposal that at the leading edge of this boardwalk on both ends, that a network of vertical posts be done in such a way that you're not going to be, you're going to have to meander through it to walk, which is wonderful, but you're not going to get a machine through there. So that's the only thing I would add. Other than that, great project.
Thank you. Jack?
You know, it should allow trail bikes, though, pedal trail bikes. But that's consistent, I believe, with the town farm rules and regulations. And I am supportive of this project.
Al?
I have no problem with the project at all. I don't support changing any of the rules at this time.
No, they're not.
Okay, all right.
No, they are the same.
Okay, thank you. I'm all set. Thank you.
I have no questions.
No questions?
All right, so this is a public hearing, and we have an abutter, Dave Rand, here. I'd like to address you.
Hi, Dave.
Hi, Dave. It's been a while. How you doing?
Excuse me, but math and hearing aids don't go together.
You can take your mask
And
down if
so,
you want to speak, Dave. It's okay.
My ability to hear what you men are saying is almost impossible.
Sorry about that.
I met with the town manager this afternoon and conservation officer and the Board of Health. And my neighbors and I have some serious considerations about anything being done in those woods in the rear of our house until the flooding situation on our property has been taken care of. I've been arguing this situation for 35 years. In 97, 98, 99, 2000, I had permit from the state of Massachusetts to remove the beaver dams in the back of my property because my septic system was flooded out. And I did that for that length of time. When the sewer line came down Dale Street, I lost my ability to argue that point about my the sewer, my septic tank running into Lake Chickway. But there is still septic systems running into that area in the rear of our property. This year, the whole area out there turned green. And the Commonwealth of Massachusetts issued a warning to everybody, and so it was close to these ponds, that these ponds were deadly as far as animals are concerned. If one of your animals drank from those waters, that would be fatal. And so for the last 35 years, I've been trying to convince the town of North Andover that that area should be returned to what it was before the flooding started. I have a bunch of material that I was ready to bring here tonight, but I was under the understanding that this just wouldn't come up tonight, that it was going to be postponed. I had other members of my neighbors that were going to come in here and speak to you tonight about it too, but I inadvertently told them not to show up because.
I think we said we'd start discussion.
Say again, please.
I know that with Melissa, we talked about starting discussion tonight, but she asked if we could please continue to the November 17th meeting because she's going to go out to Dave's property next week. So she just wanted a chance to get the lay of the land and just asked, the commission to indulge her just a little extra time, just to understand it.
Who wants time?
The town manager.
Okay, so why don't we just continue
Okay,
this then?
I know, I just want.
Let's hear Mr. Randall, he's going out of his way to come
The
here
town
tonight.
manager has an appointment with me Wednesday, the 3rd of November, to come to my property because she wants to see firsthand what's happened to our property.
So I agree with that.
I can't,
Me too.
I can't be forceful enough to remind you of the destruction that's happened in that area. This year, I went down to the old town farm, down to the playgrounds, and I sat there for a moment, and I watched all the little children playing in those playgrounds. And then it dawned on me that we had just had a notification from the state of Massachusetts to be very careful about these surrounding swamps. And each one of those little children is more susceptible to the bite of a mosquito carrying a deadly disease than they are for COVID-19. The science that we're beginning to understand today says that the children aren't very susceptible to COVID-19. COVID-19 would probably kill me at my age, but to them, it probably wouldn't be fatal. And so I went to the Board of Health this time, and I said, please do something to alleviate the situation on our property and drain these waters back to where they were for almost 100 years. In the 1930s, President Roosevelt, which none of you really remember, had a program called the WPA. And the WPA came into that area and they dug ditches. The ditches are probably 6 feet wide and probably 6 or 8 feet deep. And they run all through that property and they lead all the water to Lake Achicowit. Now there's one area, especially the area where these people are proposing to put the walkway. There was a huge piece of ledge. And for the years that I was able to take out the beaver dams, I kept looking at that piece of ledge And I said, if I ever lose the ability to take out these dams and the beavers find that ledge, the whole area is going underwater. And that's exactly what's happened. When I lost my ability to take the dams, and you know that when you do remove a beaver dam, you have to have the permit on your person when you're working on the dam. And so I lost my ability to take out those dams, and the beavers hit that piece of ledge. And that piece of ledge is solid right now. And that controls every bit of the water from the town farm properties, all the way over to Castlemere, all the way up Dale Street. And so all of us, all the people that surround that area, are affected by that contaminated water. And so I thought before I came here tonight, a couple of weeks ago, I made an appointment to sit down with the town manager and go over the situation with her so she would know what I was coming in, my neighbors are coming in here and complaining about. And so we had that meeting this afternoon. And she said, I would like to come out to visit your property and see exactly what you're talking about. I said, I would love for you to do that. Because I said, you're the first person in 35 years from the town of North Andover that has actually come out and looked at the situation. And so, again, I'm asking you not to make any determinations on anything, because if we get the approval to remove one beaver dam, that has to be removed very, very slowly. I've gone over this with DPW and I understand perfectly. If you took the dam out completely in one day, you would wipe out the North Andover Country Club. The culvert on Great Pond Road next to the North Andover Country Club is either 18 or 24-inch culvert. The water in that area is so, there is so much of it, that within an hour of that dam going out, that culvert would be overwhelmed and the water would go right over Great Pond Road and right through the North Andover Country Club. About 2 or 3 years ago, I took the manager of the North Andover Country Club out and I showed him the dam and I said, God help you if this dam ever goes out. And I asked him at the time to come in and try to deal with you people to alleviate the situation. And they didn't do it. They never came in, they never mentioned the fact. But again, the DPW knows exactly what they have to do. That one dam will rectify that whole situation, and if that dam comes out, there's a strong possibility that these people won't even need walkways. Because the water bill will be reduced, as it was for 100 years, running in the ditches that were put there by the WPA. You know, as conservation people, that the best way to get rid of contaminated water is to let it run freely. And that's exactly what has to happen. Now that place on the left there where you see that word town farm. In 1952, 1953, I was in the service at the time, but there was a fire. That was Leland's pasture, and there was a fire on that pasture. My friend Donnie Fountain was driving the fire truck that day, and all of a sudden the fire truck started to sink into the ground. And Donnie got in and he backed it up. And he called the fire chief, Jim Dawn, and he said, Jim, what's going on? And so they spread out and they determined that what had happened was that the fire in the Leland pasture had found a stump and it had gone underground. And it hit a peat bog. And the peat bog was on fire and nothing was going to put it out. no amount of water until the rains came. And so they had to monitor that area for a long, long time until the rains came and finally filled up the Pequot. If you stand on that driveway today, going in off Castlemere, and you look at the area, you think maybe there's 3 or 4 feet of water. And in fact, there's probably 60, 80 feet of water. We don't know how deep the Pequot is. But all that pressure is there. And my yard, my backyard, is the low point on the whole of Bear Hill and on the whole of that area. And every time it rains, my backyard fills up with water. Last week I went to mow my backyard with my mower, and my mower sank right up, all 4 wheels. Luckily, I have a tractor, and I could hitch my tractor up and pull the mower out. But this is what I'm going to show the town manager. So I'm asking you, please, don't take any action on this area at all until we determine how we can best rectify the destruction of our properties. Thank you.
Good to see you. Hang in there.
Could I say a word? I'm Dan Mancini at 12 Carriage Chase Road, up shown on the plan. So my property, I would echo everything Dave said in terms of the water condition. We don't have to hash it out further, but it's really high. Amy's been out to the property. I've been there 3 years, so I don't have a track record going back further than that, but it's high. It's elevated quite a bit in just 3 years. So that's an issue, just in terms, I have young kids, mosquitoes, the whole thing. It's a problem. I've engaged an attorney who has reached out to Rob Jones. He was kind enough to respond to him. I saw the response in terms of the trail and the proposed area in green, I believe, is where you're projecting the loop to go back down towards Dale Street, right? My concern, being on Carriage Chase, and my driveway is a quarter-mile driveway from Castlemere down to Carriage Chase, and then lead up to my house that's at the back. The problem I have is if people start walking beyond the trail into the woods, maybe sometimes a year it's not possible because of the wetlands, maybe it is. If they start walking out into my driveway, it very much looks like a utility road. We've had issues, we've called the police, people walk on it all the time that shouldn't be there. Liability, safety concerns, I just don't want to promote people walking down my driveway. Is there any possibility to put something up along the trail to try to encourage people to just stay on the loop? That would be my concern. I'm fine with where it is if people stay there. I just know that that's not always how it, works out over time. Those are my concerns.
All right, let me add to some of the things we just heard tonight. So, one, it's rare that we hear any opposition to promoting trail improvements along an existing network. If we're looking to do something beyond existing, it's something that we want to be aware of. And I'm not so much hearing that other than what I just heard now. One of the challenges that I've had ever since I've been on the commission is recognizing it's very difficult to convince people the importance of what it is we do with regards to wetlands. And the more we can get people out into our properties and into our wetland areas and adjacent to them, the better appreciation they have for those properties and what it is that we do. And in the overall interest of what it is we do, it's how we educate the public. So I think I always try to balance that access to our spaces. It's why we acquire open spaces. I try to balance that for what people can learn to make our mission better. At the same token, never depriving any private party adjacent to us of any rights that they might have. Dave, you're tenacious. You've been at this forever. I remember you, as long as I've been on the commission, dealing with the beavers. I know that. You're not hearing any of this?
No.
Yeah. I'm not sure we get subtitles on. You can watch it at home. Is it any better when you read my lips? No. You can't. Can you hear by looking at my lips too, or no?
I can understand better when I can see your lips.
Okay, so I'll try to do that. So you have done a great job promoting the importance of the flooding. It's almost tangential to the plan that they're proposing. It's important, but I don't think it has anything to do with the trail network or the improvement of the boardwalk.
there's an area in back, and I'm sorry that this is happening tonight, because I thought that it's.
We're not gonna finalize it. I'm gonna walk this weekend. I'm gonna walk this area this weekend as
No,
best I
but
can.
I have a series of pictures that I've been taking since 1968 that show you exactly what that whole area was like.
And I understand that that's all history. It is very important history, but it's got nothing to do with the trail network or the boardwalk. It's important. It's important to you. It's important to flooding.
The boardwalk, the boardwalk.
We don't have a quorum right now.
is proposed.
What's that?
Use something in a second. All right.
We have a quorum again.
The boardwalk is proposed to go in an area where if the dam is open and water is brought back to where it was originally into the ditches, they won't need the walkway. You won't need to go in there and do anything.
Yeah, but-
Because I put, Jim Rice from the Boston Red Sox used to live across.
Sure, I knew where he lived.
This thing.
I think Adam Oates used to live in your abutter's house.
This thing came to a head when Jim Rice was living in that property, because his property was flooded out, and my property was flooded out. So Jim Rice and I and Harold Morley got together, and we had to go to the state of Massachusetts for our permits, and we did, and they immediately gave them to us.
And David, I'm not arguing any of that. What I'm saying is, and again, you didn't hear me because I had my mask on. What I'm saying is, we have to balance the overall value of the property from an environmental perspective. We have to look at the educational component we get when people are able to get out and enjoy that and understand better the beaver problem, the flooding problems. Those things kind of work together. So your flooding problem is real, but it really has nothing to do with their trail or nothing to do with their boardwalk.
It has everything to do with it.
I'm not convinced of that yet. I'm gonna walk it, take a little hike this weekend with my family, my wife.
Come to my house so I can go with you.
Can I make one comment about that?
Sure.
We're downstream from the beaver dam on the eastern edge of the
Yeah.
property.
What I see as a possibility is that they're using, David's been tenacious for decades. Whenever there's an opportunity to bring his case forward,
Well, I
to
understand.
hear about the flooding problem, the beaver problem, which is real.
I understand.
It's real.
completely, And it's a
He
legitimate concern.
he takes advantage of that opportunity to be able to get that message out.
Yeah.
This is that
What I'm
opportunity.
saying is, we're downstream of that beaver dam on the eastern edge of the property. It's wet, even if that beaver dam was gone and all the water was drained out. It's a perennial stream that would need a boardwalk,
I
so,
think overall, not having people traipse through the wetlands is probably better for
yes.
everyone.
Right.
Having said that, I think the town manager asked us to take some time. Mr. Rand's asking us to take some
And I'm
time.
gonna walk it, we're gonna take
Joe's
some time.
volunteered to take a look at it, so
We're all
I
good
think
with that.
we're all on the same page, and, you know, if there's a way that, we could find a way to help with the beaver dams.
If this gets discussed for a meeting or two more, it doesn't affect your schedule. You guys are volunteers. We appreciate the work you do everywhere. We appreciate your effort here. We'll see where it goes.
Yeah, we're fine with that.
If I may just offer a suggestion, most of what we've seen in the woods, they,
Under the circumstances
Yeah.
for accessibility,
Yeah.
just so.
Yeah.
sorry about that. So most of what we've seen in the woods where there's tons of beaver flooding is you can remove dams and they're rebuilt within a year. I mean, you have to continuously do it, so the more permanent solution is a beaver deceiver, typically.
So I was gonna say, if it's tributary to the water supply, if maybe we could get the water department, water treatment on board, we might be able to get a permit for a beaver deceiver. It's a lot of
We-
steps, but I think at least it's been brought up. We have 3 weeks
Yeah.
to kind of work on it, and maybe we can start pushing for those avenues, and with the town manager's help, maybe that's something that could be possible and help everyone.
Absolutely.
Let me just add, when it comes to beaver deceivers, I've had one on my property now for more than 20 years, and they absolutely work. More than 20 years, and I haven't had a single stick put back in that culvert. Every now and then, you might have to repair some of the fencing, but it was the single best decision I ever made. It saved 9 acres of land from turning into a pond. And that's really a great solution, is the beaver deceivers.
If I could just make one quick comment as well about the 12-carriage chase question that Mr. Mancini brought up. I'm Glenn Aspesley at 1132 Salem Street. This town farm property that's north of Dale Street here, there's actually an easement on the 12-carriage chase driveway to access this property. There's a pedestrian easement because it was an old right-of-way. But it's never been a very good right-of-way. It's sort of awkward and weird to walk down a long driveway, and it doesn't look like a trail, and also you end up having to trot through the mud to get anywhere. So we've never shown that on any of our trail guides for that reason. And I just wanted to mention that one of the goals of this project, giving access from the Glenny Woodlot property, works in favor of having people not go down Carriage Chase to get onto this property. So we're essentially using Glenny Woodlot as a gateway to access this property that hasn't really been accessible by any other means before, other than that driveway. So we're looking forward to getting people out there at some point.
All right, so what we have to continue to the next meeting, is that the plan?
Next meeting, yeah.
Oh,
One more speaker.
Sorry?
Can you be brief?
Well, you've been talking about beaver dams for a long time.
We're gonna lose our recording secretary at 10 o'clock. We really want to get all this stuff done.
Okay, I appreciate that. My name's John Schrader. I live on Village Way. So I gather that the green thing is the pad where your boardwalk's going to be. Roughly, how many people do you anticipate using it?
Annually?
By any measure you have.
There's I'm sure you've seen the driveway that was installed at the Glenny Woodlot entrance there.
The parking lot.
It's probably, yeah, the parking lot's probably, what do you say, 3 or 4 cars?
If you're lucky.
Parked carefully.
No, I realize that. I'm just.
So not a huge destination, I would say. Probably also get some neighbors in there.
Well, first let me say I'm all in favor of this, and I appreciate it, and I look forward to it. So I'm nothing negative about it, but I am curious how many people you anticipate.
In our experience with areas of this size, I would say not busy. Just a handful of people in the morning.
How close to the property lines do you anticipate the boardwalk being? Because the way you've got it shown, it's right up against my yard.
Amy, do you remember what the width was?
It's a pretty narrow section going through.
At that scale, you're probably looking at 50 feet between them. Where that
I'm sorry, how far?
Oh, I mean, where it necks down, I'm just guessing it's probably at least 50 feet across. So we're talking, what, a 4-foot wide trail?
Yeah.
Yeah.
But it's going to be right up against the property line, as you've shown there?
It's maybe 10, 15, 20 feet from the stone wall that's
Right.
there now.
Okay.
The current way to access is over the stone wall right now, and we're trying to get people onto the property off the stone wall.
Okay, and you're going to run it from the parking lot back?
So there already is a trail through the Glenny Woodlot property.
There's a road, there's that old road.
Old road, right. And there'll be a small section of trail to connect to the boardwalk.
So the boardwalk starts after the road?
Yes.
Okay. Well, I think you're doing great work. I appreciate it. I look forward to all the people coming in.
Thank you.
Set up a lemonade stand.
Gentlemen, I had horses. When my children were growing up, my children asked me if they could have a horse. So I built a barn in my backyard, and we had 2 horses. I could take my horse, and I could ride my horse down to Leland's property. I could ride my horse through Leland's pasture, which you now designate as the town farm property. I could cross the one area of the brook, which was a stone dam. I don't know whether any of you have ever seen a stone dam. But years ago, when farmers wanted to cross a wetland or a brook, they made a stone dam. They put huge boulders in the bottom, and on the top they covered it with smaller rocks. and the water could flow freely through these stone dams. Well, there was a stone dam, and I have a picture of it. I showed the conservation officer this afternoon. That stone dam was there. No, I don't know what's left of it now, because that stone dam on the top is exactly the rocks that the beavers pick up to put in the dams. So it might have been damaged to a certain point. But I could ride my horse across that stone dam, and I could come out on Dale Street, and then I could go across the road to the town farm, go up over Town Farm Hill, and come back down Appleton Street, with never getting my feet wet. Never. If I were to do that today, I would need a rowboat. That's underwater. It's all underwater. So to say that none of this is, that the walkways aren't impacted by this, or that they don't have, is totally wrong. The walkways probably don't need to be there. And there's a beautiful flat area there where the kids used to go in years ago and build camps and have fires at night. And if one dam is taken out, it's a control dam for the whole area. And if that dam is taken out right and properly, and the water is let go a little bit at a time, and it would take 2 or 3 weeks or a month at least to do this. The water in that whole area would go down again to exactly where it was, running freely and clean to Lake of Chickward for 100 years.
Thank you, Dave. All right, so we need a motion to continue.
Second.
All those in favor say aye.
Aye.
Opposed? That's unanimous. Thank you. Next one is RDA for Commerce Way. This is an easy one. Huh?
Okay, so this is a proposal for installation of a new guy pole on Commerce Way to support an existing pole across the street. The pole is about 28 feet from the BBW. They moved it in order to stay out of the 25. It's in an existing mulch bed. And let's see. Work will involve installing the telephone pole will be completed with a bucket truck parked on Commerce Way with an auger to make the hole. Excess soil will be removed off-site. So this is a very straightforward project. It's just that it didn't quite fit into a small project. Mike Toohill's here this evening if you have any questions, but I recommend closing and issuing a negative number 3 with pre-construction conditions and post-construction.
Thank you. Joe?
I really only have one question is, have you coordinated underground utilities? Is there any drainage in the street that this pole may interfere with?
Mike Toohill from Conoco Engineers and Scientists. The engineers have looked at that. This is actually, it's a guy pole, so there's not going to be electric wires running from this pole to the other poles.
Yeah, but it's anchored in the ground. I just want to make sure that, and we can condition that as part of the requirements of that,
Sure.
Utilities be coordinated. DigSafe requires you to do that anyway.
Correct, correct.
I'm all set.
Okay.
Yeah?
No questions.
Yeah.
No questions.
Just one question, Amy, as belt and suspenders, a waiver request was also submitted. They don't
Right.
need a waiver request, right?
Well, it was belt and suspenders because it was in the 50, but,
Okay, well, they don't need one, we don't have to ask for one, right?
okay.
Tony,
No questions?
motion?
Move that we issue a -3 with the following conditions: pre-construction, excess excavated soils taken off-site, and post-construction.
Second.
All those in favor say aye.
Aye.
Opposed, that's unanimous. Thank you.
Thank you.
Thanks, Mike.
Next
Nice
one
to meet you.
is 242-1824, 177 Great Pond Road, request to continue to November 17th.
So move.
Second.
All those in favor say aye.
Aye.
Opposed, that's unanimous. Next one is 242-1770, 456 Summer Street.
Alrighty, let's see. Okay, so Commissioner will recall, this is a, existing order that governed construction of a garage in the buffer zone. The order has been modified to allow for access through the buffer to construct the, new in-ground pool, which was out of the buffer. So now they're coming before us for a second modification for a proposed pavilion planter box that are just, pavilion and planter box that are just inside the buffer zone, a shed that's outside, and the 36 by 24 garage, which was originally going to be 51 feet from the BBW, is shifted closer to the house, so now it's 60 feet. They're maintaining the proposed infiltration trench on the garage side, and the applicant, although not shown on the plan, the applicant had mentioned to Taylor and myself, she was wondering if she could add a stone trench on the opposite side of the driveway, which is sloped and where the septic system is located. And I would advocate for that because I think it's a good idea. So, let's see. So, I think it's a straightforward request for modification. I recommend approving it as presented.
Joe?
I remember this application being hotly debated during the initial permitting process, but it seems like all those things that we were concerned about have been preserved or are made better in this case, so I'm all set.
Thank you.
I have no questions.
All set.
Don?
Yeah, I'm all set, as long as the erosion control's repaired as noted.
Yep, yep.
So
Erosion controls need a little.
The stone drip, if you will, drip area, now where's that, it's not shown on the plan here.
It is,
Is it?
yep. So,
Is it the proposed infiltration trench? Is it that
proposed
one?
infiltration trench, see at the top,
The dash green line.
dash green line around,
Dash green, got it,
at the
okay.
edge of drive and around the, built, the new garage.
Okay, all set.
Yep.
Motion?
Move that we approve the modification for 242-1770.
Second.
All those in favor say aye.
Aye.
Opposed, and that's unanimous.
Thank you.
Thanks for coming.
Well, you wish you got a history lesson anyways.
I know. I know.
All right. This one's gonna be short and sweet based on my
The
242.
the Ray Street certificates of compliance, 242-1739 and 1755, we received a request for continuance. Ben had to leave, so we'll continue to 11/17.
Second.
He left, and he texted me saying, I need to continue because I gotta go.
So 1739 and 1755
Yes,
both?
yes.
Move twice.
Need a second? You have a second. All those in favor say aye.
Aye.
Opposed, and that's unanimous. COC 242-1793, 101 Foster Street.
All right, this was an order issued in August of 2020, governed replacement of a failing septic system leaching field pump chamber. Everything was out of the 50. Wetland markers were installed, and the site is stable, and we recommend issuing a COC.
Any questions, Joe?
I don't have any.
Jack?
None.
Al?
No questions.
Tony?
None.
Motion?
Move to issue a full and complete certificate of compliance with ongoing conditions as prescribed in the order.
Second.
All those in favor say aye.
Aye.
Opposed, and that's unanimous. Next one is 242-1746.
Alrighty, so, this is a request for a certificate of compliance for the order that governed, demolition and reconstruction of an old existing pool that was built in the 1970s. So the order required restoration plantings. The 10 native shrubs have been installed in April, but we haven't gotten our 2 years of growing seasons under our belt yet. But other than that, everything's in compliance and stable. So the commission could issue a partial certificate of compliance, keeping out the restoration plantings and possibly reducing the bond by half, which would be $1,000.
Joe?
I don't have any questions.
Jack?
No, one question.
Yes, I have questions. What's the bond right now?
2,000,
2,000, they want 1,000 back?
yeah.
And
I mean, that's what we could do for them. if you want.
what's the cost of replacing the plants if they all fail?
Oh, Taylor's confident that $1,000 will be more than enough to cover it.
Okay, all set, thank you.
Yep.
Tony?
No question?
Motion?
I move that we issue this
Partial
partial certificate
certificate.
of compliance for 242-1786.
Second.
And with
Release
a
$1,000.
$1,000 bond reduction.
Second.
Joe seconded that.
Yep.
A motion and a
Second by
all
Joe.
in favor, say aye.
Aye.
Opposed, that's unanimous. Okay, enforcement on 16 Ferry Street, Gibraltar Place.
So the seated areas are coming along, they're still a little patchy, so we're just gonna recommend keep those erosion controls in place, and we'll visit it in the spring, late spring, for better growth. But that's it.
Do we need a motion to continue the enforcement order? or is-
So, did you amend the enforcement order?
No.
Are you
Keep it in
amend-
place.
Are you
Not-
amending it, or is it?
No, just keep it in place.
So this is just a status report?
Yep, just status report.
Take no action.
Take no
Take
action?
no action. Yep.
Okay. Next one is 40 Flagship Drive.
We're 40 Flagship, so the detention basin is prepared and slopes are fully blanketed. All slopes that have been loamed are fully blanketed. So we're at the point where we're in a holding pattern. So they're gonna probably continue to pump out that upper area, which is bermed off. So we need to keep Jack in place to observe that pumping. And in the meantime, I expect a notice of intent to be coming in for the November 17th meeting. So I think it's status quo.
So the pumping on the upper basin has not been cleaned?
Friday, Maureen and I, it wasn't clear enough, so,
And it's been raining for 3 days now,
right,
and it's gonna start raining again the day after tomorrow.
right. Yep.
So how do we handle the upper part? It's gonna get
It's
inundated.
gonna,
It's gonna get inundated. Where can they pump to? Where can they pump to not clear water? They gotta dewater it.
They got a
Yeah.
filter pump.
It's not filtering, it's
well,
been-
they weren't watching it at that moment. I get it.
I don't even wanna go down that road
No,
again.
I know.
About somebody not doing what they're supposed to
I
do
know.
again.
I know.
That's always the discussion. It was somebody wasn't there, somebody didn't hear the alarm, somebody wasn't, whatever. The human error thing is starting to go right up, okay?
Well, at least he didn't say it was COVID.
Right.
Well, I mean,
Where were they pumping the upper pond to?
into the catch basin.
And the catch basin is what just got cleaned up. The lower basin is what just got cleaned up and mucked out, right?
Yeah.
So do we want to have them pumping muck back into the
No.
catch basin?
No,
So we should be
clean them out,
ordering them to
clean out.
put a frac
CVs.
tank up there,
Is it-
pump to a frac tank.
Is it the town's catch basin? or
Yeah.
the-
Yeah.
Yeah,
No,
okay.
it's the
The
town's
one that they
pump.
did
Yes.
before.
No, it was the soil manhole the last time, that's what caused the major problems. But
Say it
still,
again?
They were pumping to the soil manhole the last time, but this
Yeah, but
is,
this one, I'm talking about the detention pond at the bottom of the hill.
yes.
That just got cleaned up and just
Yeah.
got,
Yeah. And I think they're pumping to the catch basin in front of that, right?
Right.
Yes.
so they can't.
So it's bypassing and going out to
So
the
they
wetland.
can't because it's
No,
not
they-
clean.
No,
Right.
they can't.
So, but they're gonna have to de-water, so where do we have them pumped to?
I thought they were pumping to the lower basin.
No, they just cleaned that up.
They
Yeah,
just,
I
they just,
know, but,
Leaving it
okay.
alone.
Yeah.
It's, all right. They don't really have many options. I think frac tank is.
so they can no longer pump to that manhole. They
Right.
gotta pump to a tank up there.
Yeah.
They can't, as long as it's dirty and cloudy and turbid.
Yeah. Or they can bring out their filter pumps and
They would,
have
they
someone
they
watch.
did have
to
the
do
filter,
that 'cause
they
frac
did have a
tank's
filter
not
pump up there.
practical for this much water.
No, they did have a filter pump up there, but they.
Yeah.
No, yeah, they did, I mean, they did.
They
It was
did.
the
and they
filter,
took-
the
But the
filters
guy that
were,
was running the pump this time wasn't, changing the filters.
Okay, so,
And it was supposed to be monitored by Jack Sullivan, and it wasn't.
okay, so how do we rectify this?
well, we can fine them.
So, I mean, that's,
I mean,
that's
let's
where,
get-
that's
let's
where
get-
we're at here, because we've already given the order that they have to, it has to be monitored, it has to be filtered, it has to
Right.
be, we've already given all that stuff, and we just,
Yeah.
you're telling me that it was discharging into the stormwater system not clear.
Right.
You know, I'm growing tired of it.
No, I know.
Maybe we get somebody other than Jack Sullivan.
Well, if they don't call him, it's not his fault.
Yeah, I'm coming in at the very end of this, and I apologize for having to excuse myself. There was a discussion about relaxing the inspection requirements and the overseeing of the pumping, and we debated it back and forth, and developer was at that meeting. And it was clear that we were not gonna allow them to do any pumping without,
Right.
supervision. And so.
And it
to have- to have done-
it went unsupervised again.
So to have done
The
that.
grown-up
tells me
left the
it's-
room.
It's a blatant
And
violation.
they were, and it
I
was,
think
it
it's
was,
worthy of a
enforcement
fine.
order.
It's worthy of a fine.
So what do you wanna fine him?
what's the maximum fine? $100?
So we do non-criminal dispositions? Is that what this would fall under? Or does it fall under a bylaw?
I think it's bylaw,
Okay.
violation of, a condition of an order.
Yeah, so if it's not stated as such in the regulations of bylaw, then it falls back on non-criminal, which is $25 a day, every day being a separate violation,
And
and
you guys,
subsequent offenses being,
and you guys have given him a lot of leash because of.
we did, and we attempted to, we had that discussion about monitoring, with him here.
Right.
And with some pushback from
And the
his end.
guy's sitting here asking to dig a foundation. I'm like, I was,
Okay, so
It's
Fine.
$100 a day.
it's $100 a day, right?
So this only happened the one day? As far as we know.
How many
That I, right,
So it's $100.
You caught them on one day, you caught them on Friday.
yeah,
So for Friday's date, they should be issued a fine of $100
Yeah.
for violating the enforcement order.
okay.
To it discharging unclear water into the resource. And with respect to the action tonight, they cannot pump, they cannot start repumping without a monitor on site 100% of the time.
I want to be careful how we say that. He has to maintain discharge control, and at all times that he's pumping, he must have monitor on site. Meaning, we're not telling him to not pump and therefore, create an overtopping. We're telling him when he's pumping, he needs to be monitored, but he
Well,
must
we're saying-
always, but he must always maintain
We're saying two things.
discharge
We're
control.
saying you must pump. And we're saying, and you must have the monitor on site, and no exceptions.
Yeah, I don't want it to be construed that we're telling him not to pump.
No, yeah, no,
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 I'm
right,
not-
all
I'm
right.
not
I don't
saying
want,
that. I'm not
he's
saying
thick
that.
as a brick, I don't want to give him anything to think about.
I'm just, every time I read this paragraph, my blood pressure goes up. You know,
Okay.
what
So
what
do you
what
want to
about the
vote
fact-
to amend the enforcement order to just give me the ability to fine every single time I see any kind of violation?
Yes, you already have that. You don't need the enforcement order to do that. You have that as a conservation agent.
Read the preamble
You
to
have
that, what you just
enforcement-
read where the fine is established. Read the preamble.
Under chapter 131, section 40, you have the ability to take enforcement action. You already have it. But if you want it to be restated in the EO, I will.
Now, that
Okay.
$100, it's probably chapter 40, is it 40?
190, our bylaw?
No, in our bylaw, that section that you just read about the fines,
Yeah.
the preamble to that probably cites the state law which you can issue.
Oh, yeah, MGL Chapter 40, Section 21D.
That was what I was saying,
There it
chapter
is.
40, there it is.
Okay.
They just say, that gives you the authority to issue that fine
Okay,
on the
all right.
spot.
And you can issue the fine, the violation notice and the fine, you can repeat it every day that the violation has occurred.
Yep, yeah, okay, I just,
Now, what about the frac tank?
No, that's, no,
Forget it?
I've come and gone on the frac tank.
Okay.
They have to discharge clear.
Okay. Yep.
It has to be clear. If it's not clear, they can't discharge. They can't pump. And we're saying to pump, and we want it filtered, and we want it clear.
okay,
And the day that the observation was made, which you have down was Friday,
yep.
on that date,
Yep.
when the violation was observed, that the fine is $100.
I'll issue a fine.
And
And
it'll
for
be
any day
$100
that
every
I-
ti- It'll be
okay.
$100 every time, and we're not
Okay.
gonna, rescind or reconsider. Don't even ask.
Mm-hmm.
I guarantee you, we did it yesterday and today.
Well, if we don't have a grown-up on site, we're not gonna know. That's been the
Alright.
problem right along.
Okay.
That really has, to put it as
So is
crudely
that a
as I can.
vote? Is that a vote? Do you want to vote that?
So that's my
I just
motion.
I want it to be really clear that you guys gave me
Okay,
that
I'm offering
ability,
that as,
that's all.
as a motion to annex that, add that to the enforcement order, or amend the enforcement order.
All those in favor say aye.
Aye.
Opposed, and that's unanimous.
All right, great, thank you.
All right? 268.
268 Raleigh Tavern,
I
so,
recuse myself.
oh, yeah, okay. So the commission issued an enforcement order requiring the offending patio corner that encroached into the 50 to be removed no later than today. It has been removed, I have photographic evidence of that. And they need to submit an after-the-fact RDA in time for our November 17th meeting. So they have all of the application materials, they have the deadlines. I've reminded them twice, so, and
Okay.
our deadline is next week, so.
And
So they're,
you haven't had any correspondence by them?
Jonathan Grasso
Have you
contacted.
you have talked to them?
Yes,
Okay.
yes,
Because as soon as communication is started, we will issue an enforcement order and start fines.
right,
Because this has been going on for a long time.
right. Mhm.
I think, don't they
So
have?
do you guys want to, so the enforcement order talked about fining if the patio wasn't removed. Do you want to fine if the RDA is not received?
Yeah, everything that the enforcement order says, on the date certain, has to happen on that date.
Right,
I mean, we say do it by this date, that's,
right.
you,
No, I know, but the way I wrote it,
out a couple of meetings to give it time to do that too.
yes, we did.
so when did,
Right,
it was issued on September 29th.
right.
So I thought we were generous to.
Yeah.
And it's now the end of
they're-
October.
They're done, but it was shooting for the November 17th meeting.
So if they don't have it done by the 17th, on that night, then the first fine of $100 should be issued.
Right.
Okay,
And it's,
That's what a deadline is.
all right.
yeah, you don't need a professional engineer or survey to do an RDA.
No, I know. No,
Okay, 60
And it's an
Camp,
after-the-fact idea.
right,
right, okay,
right. 60 Campbell, we did.
Are you good on that?
yeah.
Okay.
64
Nutmeg.
Nutmeg Lane. And the only why we were supposed to start fines on that one too, but we're not going to because you said you've got Greg Hartman on the.
Yeah,
doing a
so
site
they've
review.
engaged Greg Hockmith to delineate their wetland. He said he was gonna do it next week, and I'll walk it with them, so we'll just continue to the November meeting for that one.
I move that we continue that one to November.
Okay, motion, right? You don't need a motion, right? Okay, that's all.
All right.
Next one is 597 Foster Street. We just did that one too.
No,
No,
so,
we didn't do this one.
We just approved the CLC, didn't we?
no, so this project was, for a septic system upgrade.
Oh, I'm sorry, give them a different one.
The new owner took over, actually, he and his father built the septic system, that's their business. He was at the pre-construction, he moved in. We did do monitoring, we suspended monitoring when things were stable enough, and then we wanted to pick it back up in the spring. It sounds like Norse did do a spring inspection. I wasn't aware of that. So the homeowner went ahead and removed the erosion controls and brought in 2 to 3 inches of loam to even out and get some better grass growing. Luckily, even with the past 2 days of rain, we have no erosion, and the grass is growing. So really, the violation was removing the erosion controls and doing work between erosion controls and wetland markers, but right now, we're mainly concerned about the tree, and we're asking that they reestablish the root zone to get that back in contact with the air. And so right now, we have a stable situation, and he needs to go for a certificate of compliance.
Is the order still valid? So it hasn't been
Yes, yeah,
So basically, all he has to do is file for the COC.
he does, yeah. And do the tree,
And do an as-built, right?
yes,
Yeah,
yes,
So that's what he has to do.
yep.
that's
Yeah.
what the as-bilt's required.
So what do we have to do to get him to do that? Because there was a very
Well,
lengthy letter written.
No, I know,
Yeah.
Saying that
know.
it was our responsibility.
I know.
Okay, so what does he need to receive to get him
He
to
needs
file a
the
COC?
checklist, certificate of compliance checklist.
Does he need a letter from the commission instructing him to file
File for
for a
COC?
certificate of compliance, and the checklist will be attached on how to
Yep,
do it and what to do?
sure.
Does he need that?
Probably good belt and suspenders.
Well, I mean, you tell me, because.
I think so,
As part of the enforcement order?
yeah,
Okay.
I think you can,
So all you want him to do is file for a COC and
File
follow
C-
the checklist?
right, and then take the loam away from the tree trunk and,
I would think the enforcement order would be take the loam off the tree trunk,
yep.
Yep,
and then it would be a
file a COC.
gentle reminder that he has until the order expires to file for a COC.
Without making a more assertive position, and those things, they can choose to never
Right.
request a certificate anyway. So I think, given the fact there's a violation out here, I think it should be part of the order that it says
Yep.
that upon completion of work, you must file for certificate
Yep.
of compliance within 30 days.
Okay.
He's gonna file it once, he's demanding his bond back.
Because, and that's the real rub here. There's no bond release without a COC.
Oh, I know,
And you want an as.
right, and I explained that to him.
Okay,
want
so,
an
I
as-built.
so just send,
Okay,
Well,
Yep.
the as-built is required for NOI.
yes,
as I look
So
at
make
this
sure-
map,
Make sure you tell him, because he only looks at the pictures.
yep,
this, the hatched area in the wetland, there's no activity taking place there, right? Because we allowed that
No.
to, when Miss
it's
Bradstreet
just the
was in front of us,
concrete thing sitting there,
we left that there rather than have it dug out.
right,
So everybody knows that that's off limits.
yep.
And if he keeps it up, we're sending Jamie out there.
So what do you need? You have what you need, right? Amy?
Yeah,
You
I
have
got what I need, so if you want to vote to issue that amended violation letter directing him to remove, or amended violation letter to remove the loam from the tree and file a COC.
So moved.
Second.
All
Okay.
in favor, say aye.
Aye.
Opposed, and it's unanimous. Okay, decision time.
All right,
Didn't think we'd ever get here, huh?
I'll try.
This was like herding cats tonight, man.
We had to have history of it, history of it.
all right, let's see.
Dave has earned my respect, but it's becoming a challenge.
No, I know.
What,
Or whatever.
First one is, 242, 1820, 227 Barry Street.
Yeah, yep, yep.
got an inch back.
Do you agree to move it or remove it?
He moved it. It's gone.
It's already gone?
It's gone.
So no longer, it's not relocated, it's off-site?
Right.
Okay, got it. Good.
The only thing I don't remember was there a foundation to this deck, or was it just
No,
on?
it's footings.
So do we want to require the as-built of the footings? Usually it's a requirement for the
For
building
the
permit.
foundation, right.
That
Yeah,
would be the only thing.
yeah.
Absolutely.
Footing. So we do?
Huh?
I did say installation of the footings.
I don't know what number you want to put it under.
56.
56.
56, okay. It's 2,000 and up.
May not be.
Yeah.
I just threw it out there.
It wasn't a ton of work, it was just rebuilding an existing deck, so it wasn't like you were doing.
But he's in the 25.
Yeah.
I don't think the threat's any greater, given the topography that's out
Okay.
there.
It's pretty flat. It's flat.
I would have said 2,500.
So he's got plantings, so I did, you know, May 2022 for a deadline to install those. You know, with all the regular survival monitoring.
What do you have 58 highlighted because you wanted to, I think he probably isn't gonna need it, but I think you should leave it in anyways.
Oh, yeah. Yep.
Okay.
I'm all set.
Any questions?
None.
Motion?
Move to approve the order conditions for 242-1820 as drafted.
Second.
All those in favor say aye.
Aye.
Opposed, and that's unanimous. Next one is, 242, 1823, 292 Candlestick.
Yep.
$3,000 seems more than we usually do for a pool and a deck.
Well,
What are your thoughts, Randy?
maybe it's,
You got a lot of enhancement area, too.
Yeah, he does. This is the one that we're kind of split on that
Yeah.
50-foot
Yeah.
no disturbance.
Yeah, a couple of us didn't want to grant the waiver.
So then that elevates the bond amount.
Leave it?
Leave it, I think.
You get it back.
43C, conservation grade?
yeah. Like,
Meaning like native conservation type species, or?
sort of how they're grown,
Okay, I just,
species. Like, they're grown, like, out in the elements, so they're
Gotcha.
way more,
all right, well, I just
yeah,
never came across
yeah.
it.
If there are any questions, we'll have a motion.
Move to issue the order for 292 Candlestick Road, as written. Second.
All those in favor say aye.
Aye.
Opposed, and that's unanimous. Next one is 242, 1828, 290 Webster Road.
question on 52. So the,
On this one?
wetland markers, yeah. So they're just going into the buffer. They're not like getting close to the 50 or the 25. I don't know. It seems strange to put markers all the way in the woods. You know what I mean? I don't know.
Did they show anything on the plan?
No. You know, all the way in the woods to get to the 25.
So 52 typically deals with permanent markings, right?
Yeah,
Typically.
yeah.
But in this instance, the work doesn't extend that far in.
It doesn't,
So are you,
not even to the 50.
and this was a full-blown NOI?
Yep,
So we would typically want those markers for the 25, permanent markers of the 25.
okay.
So the limit of work is really, the hay bales themselves are gonna delineate that, right?
Yes,
And the markers should be at the 25.
at the 25, okay,
Yeah,
all right.
I agree.
keep saying hay bales, siltation.
Ready to move?
Whatever you want.
I move that we issue the order of conditions for 242-1828 as drafted. Second.
All those in favor, say aye.
Aye.
Opposed, and unanimous. And last but not least, 242-1829, 920 Johnson Street. That's one part of verbiage that cracks me up, is the minor grading versus major grading. I mean, what is minor, what is major?
Major grading takes a hammer.
Huh?
Major grading, you get a hammer for.
Maybe we should define.
Oh, I don't,
We should promulgate a definition in the regulations to determine what's
I'm
minor.
striking
Less than
minor.
18 inches
We could
from
do-
the natural grade.
That's what I mean, we could come up with an absolute definition, we could quantify minor and major.
It's more
Well,
than
I'll
the-
take minor out, how's that?
If it's more, if it's more
What
than.
condition is that referenced?
Just call it grading, just call it
Okay.
grading.
It's 21. You probably took it from the notice
Should be
of intent.
first,
Harry,
any
because
disturbance.
that's the
Probably.
first line.
I know.
No, better off just to call it grading, that way there's no
Okay,
question.
all
Because
right.
if somebody ever asked that question, you
I'll
saw
let
what
you
just
know.
happened here. None of us can come up with an answer, so.
It's more than
It's like my
overall
minor
full, it's major.
modifications, they don't like that either.
It's like when we used to do the renderings by hand, we had 47 different shades of green.
That's right.
Even the pavement had a tinge to it.
Is the filter system listed in this order?
It was, copy this,
Thir-
that's-
Number 39.
39.
39, there it is.
Is number 40 new? I don't think I've ever seen that before.
Number what?
Number 40, do they have to have DEP number out there? I know they have to, but I've never seen it on the order before.
It's
Has
in
that
every,
always been
every
this on
single
every
order.
Oh, yeah.
I just happen not to see it, maybe because you highlighted it.
Yeah, well, I just do the number, make sure I get it right.
It'd be really mean and require it to sign.
So
the guys to
49.
sign The sign ordinance and make them have to go.
Yes, I know, right.
49 speaks to some of that area we reclaimed,
Right.
so I'm just gonna,
Yep,
I mean, you've got all the references correct between flags and.
yes.
I don't have the plan in front of me.
Yeah, it's sort of cut and pasting exactly what our enforcement order said.
Okay.
Just reiterating.
markers with markers.
And so I added just a little caveat about, for all of the purposes, the no disturb zone is a full 25. It's just for mowing.
I think condition 50 is stated in an awkward way. You may want to say it differently, more clearly.
Which one?
Condition 50, it's about cease and desist mowing,
Yeah,
but I think we probably should just say it in a more direct way. It kind of bounces around between reference plans and, you know,
okay,
mowing and no mowing, and it kind of just awkward.
all right.
But what we really want to say is, once this order is issued, you shall not mow the area depicted on the plan
Labeled as,
labeled as 10-foot wide, no disturb zone.
okay,
And the rest of the conditions,
Okay.
survivability is fine.
all right.
Yeah, since we're wordsmithing, that second line, shall be allowed to restore to its natural state, rather than grow back naturally.
Oh, yeah, no, you're right.
It's just a little bit.
Yeah, it's a little more, no.
Kind of like every time I mow it, it grows back naturally.
Yeah.
Anyone? If not, motion?
Move that we approve the order of conditions for 242-1829 as drafted and amended.
What is, I'm sorry, before we do, what does 51 actually say? We have two southernmost wetland posts.
Yeah, they're in the wrong.
How do you adjust them? They're in the wrong place?
Yeah, they just need to move up.
So we should say they shall be relocated in accordance with the approved plans, to a location in
Yeah.
accordance with the approved plans.
Yep. No, you're right, okay, yep.
Shall relocate.
Shall relocate
In accordance with.
in accordance with, yep, with the plan.
I didn't want that.
I like it.
Sometimes a few pictures.
So we had a motion,
Motion, second, now?
All those in favor say aye.
Aye.
Opposed, that's unanimous. Motion to adjourn.
so this is yours
Second.
for,
All those in favor say aye.
listen to all the.
Opposed, and that's unanimous.
Jamie, you got a minute and a half.